Good morning, everyone. Can you let me know if you can see me and if you are able to hear me?
Good morning. Yes.
Good morning. Okay, awesome. All right, give me 1 second. All right, so I'll be sharing my screen. So just give me. Are you able to see my screen? Anyone hearing me? Are you able to see my screen?
Yes, I'm able to see the screen.
Okay, all right. All right, so before I get into any questions, in terms of going through a past paper question, I just wanted to share some general tips with you to the exam, because one of the things that I know for a fact is that in CAPE, or well, in CXC in general, a lot of times you guys have the information, and it even carries over to university where you have the information, but you do something that we call the kitchen sink. So you write everything that you know on the topic, and so you write everything that you know on the topic instead of actually answering the question, and it's your downfall. So I want you to know that you will get questions for your year. For my year, I had a choice. So I would get 2 questions on the topic and I would have a choice, but for your year, I think everything is mandatory. And that means you might get both an essay and a problem question in one. So part A might be an essay, or an essay type question rather, and part B might be a problem question. So one thing I want you to do is that if you are answering a problem question, please ensure that your answer does not, or if you're answering the problem part of the question, please ensure that your answer does not resemble an essay. I have here that this means you should not have like an introduction or supporting paragraphs and stuff like you're actually writing like a literature essay or a sociology essay. No, you should be able to identify the difference between both questions. So in identifying which one is an essay and which one is a problem, if you see a question that says you should define or you should discuss or you should examine, then that is an essay question. But once you see something where they give you like a scenario and they say that you should advise a party, a specific party, or advise the parties, then you know that this is a problem question. So I'm going to go into how you do a problem question first. I will be with you for about an hour, going through this question, and then someone else is going to come on and they're going to carry you for about 3 hours or 2 hours rather. And then I'll come back in the afternoon and I will do the real property question. So the question that I'm going to go through first is a tort question, and the person will do a tort and a contract question as well. And then later I'll come back and I will wrap up with with about 2 real property questions, because I know that real property is a difficult area. So any questions so far? And can I just continue and go ahead? All right. So the question that I have here came from your 2014, from a 2014 law paper, and there may be some issues because I did not get to correct this. I'm so sorry about the background noise. I did not get to correct everything on this PowerPoint, but I'll do my best and go ahead and make corrections where necessary. So here I have Adam sees ahead of him in the street an individual who from the rear looks remarkably like his former girlfriend, Barbara. He sneaks up behind the person, taps the person on the shoulder, and tenderly kisses the person on the cheek. It is not in fact Barbara, but Calvin, who wears his hair in cornrows. Calvin screams and throws a punch at Adam, which misses. Adam runs off screaming. Calvin runs behind him shouting, "If I catch you, you'll see." And they ask that you advise the parties on any liability or claims that they might have or may have. I want you to avoid doing this. So you can look at it and see what I said, what I am saying that you should avoid doing. It's an essay. You come and you talk about what is a tort, and you talk about what is trespass of the person, then you go into assault and battery, then you go into first paragraph, second paragraph, last paragraph. Do not do it. Please do not do it, because I know persons who have marked this exam. I know persons who teach at the university who are actually in charge of your law exam, and they said it times and times again that marking cape is a pain because the children do not identify essay from problem question. Please, I'm asking you guys, don't do this if you see a scenario. Please don't do it. So what should you do? If the question has 4 issues, you should have issue 1, rules for issue 1, and application of principle to facts for issue 1, and conclusion of your issue. And you should do the same for issue 2 and issue 3, and it continues like that for all the issues that you identify. So explanation of the IRAP method. I know that some lecturers or teachers might say ILAC, which they might say issue, law, application, and conclusion. It's the same thing. All they do is to change rule to law, but they're all speaking about the principles or test or anything that you might find in a case or in statute that applies to the issue that's at hand. So your issue, I have here that you should note that you are answering a legal question, meaning your legal issue must include both law and facts. That's another common mistake and it caught some of us even at university, where we answer just using where we have an issue just based on facts. But you cannot have an issue just based on facts if you're going to answer, if it's supposed to be a legal question, or if you're going to answer something using law. You must give your examiners some form of law so that they know that this is the area that you're going to be looking at. So I have some issues that I found here, and I phrase them, but you guys might find something else, or you might phrase it another way. I use whether because I think it's the easiest way to use, and it's the best way for you to use, especially at the CAPE level. You can use can or do or any other question, any other way you start a question. But if you are not sure how to phrase them using those words, I would advise that you stick to whether. They're not going to penalize you for using too much whether, honestly. Well, not at this level. So what I have here is whether Adam, who gently tapped Calvin on his shoulder, can be someone saying something? Okay, so I have whether Adam, who gently tapped Calvin on his shoulder, can be held liable for battery. And then I have the second issue, whether Adam's tender kiss on Calvin's cheek constitute battery, and whether Calvin's response, or that should be, yes, or whether Calvin's response of throwing a missed punch at Adam after the unconsented kiss can be considered a valid defense. And lastly, I have whether Calvin's words to Adam, "If I catch you, you'll see," amounts to an assault. So what I have here about your rule is the law relating to that specific area. And you should introduce the topic with a simple definition and possibly a case. I learned this in court, and it is essential because there are different examiners, and we really don't know what your examiners are looking for. But sometimes they like when you can introduce the topic, because we learned that you should always assume that your examiners know nothing about the topic. So a lot of them like when you give a definition instead of just going into the specific rule to the case. So as I said, different examiners have different styles. So you might just want to use the definition just in case your examiner is one of those special people. However, one of the things that you guys have going in your favor is that your examiners are actually scripted. So they are not working on emotion. So CAPE is a little bit better where you can get a mark for everything. So even if you miss out something, you'll be fine. But I advise you to try your best not to miss out anything because you want a grade 1 and I want you guys to get the grade 1. So you can put in the definition just in case definition is a part of your script. So some things you have to ask yourself, is there a clear and well settled principle? Is there a case that I've given some, or is there a statute or something that says, okay, it's dealing with this specific area? You might want, well, no, not that you might, you need to identify that. Is there a test? Different cases may have different things. I know in tort, especially in negligence, there is, for example, the eggshell principle. You might have another area that might have a test, a 2-stage test, a 4-stage test, all of that. Those are a part of the rules. So you want to ensure that if the area has something to do with that, you have it there. Is there a leading case in which a judge or the court established a new principle or overturned the original principle? So you might have something that is there from the 1700s or the 1800s, and there's a new case, or well, a relatively new case that came in 1999, for example, and the court overturned the decision from the 1800s case. You need to identify that. So you need to identify that there was an original or traditional rule and that a new case came and overturned it, or if there was something added. So I have here, have there been any new developments on the rule? Sometimes judges might not overturn a rule, but they may decide that they're going to add to it. So if there are any additions, you want to make note of that in your principle. And then there's something I have here that, are there any oppositions to the rule? There are judges who might say they will leave the rule as is, but they personally don't think it's applicable in this case, or they oppose it for some reason, one or another. If there is a case like that, you want to make note of it. Your rule is supposed to be your most, or well, the rule is going to be packed. That's as much as I can say. You might find a case where your rule might take a whole page and your application might be 5 lines. And that might sound weird because normally when we're writing, we always think that applying should compose of most of the information, but that's not true. In law, especially because it's law. So the main thing about law is the law. So if you have 1 line for the law, then there's no way your application can be a whole page if you only have 1 line for the law. So while a lot of times we tend to probably get away if we write like just, oh, the rule that's applicable here is this principle, it is not advised. And they mark heavily for your rule because the course name is law. So I advise you, when you're writing your rule, ensure that you look for everything that is here. And it may be the list is not even complete. There may be other things. Once there is something that spells the law that is relative to the topic that's in your facts, you need to have it in your rule. So here, I wrote the principle for each issue, sorry. So here I have the question again, or the issue is whether Adam, who gently tapped Calvin on his shoulder, can be liable for battery. I have here assault and battery are both elements. So I said you should introduce a definition, a simple and short definition. Your definition should not be the entire principle, please. So I have assault and battery are both elements under trespass of the person, meaning they protect persons from interference with their personal liberty. They are usually actionable per se, which means they do not require proof. It must be noted that while they coincide with each other, assault and battery are distinguished. An assault is putting someone in fear of immediate battery, explained in Stevens versus Myers, or Stevens and Myers, and it was held that a threat of battery is an assault. However, only if there is means to commit battery. Battery is a direct act of the defendant, which has the effect of causing contact with the body of the claimant without his or her consent. In other words, and I'm sorry for any grammatical issues, sorry about that. Any contact with the body of the claimant is sufficient to amount to a battery. This is explained in Cole and Turner, where Lord Holt, CJ, noted that the least touching of another in anger is battery. So for example, to slap or punch a person would constitute a battery. However, Robert Goff, LJ in Collins and Wilcock notes that bodily contact was not actionable if it was generally accepted in the ordinary conduct of everyday life. Meaning that it is something that if it is something that is inevitable, like persons pushing against each other in a crowded space. The principle was further explained in Donnelly and Jackson, where the appellant contended that by touching him on his shoulder, the police officer acted outside of his duty. Thus, he could defend himself using force. It was held that the touching of the appellant's shoulder was a trivial interference with his liberty and did not amount to a course of conduct sufficient to be outside of the course of the officer's duty. So here you see, I have the definition and I have a case explaining the difference between assault and battery. And then I because the question is based on battery, I did not want to spend too many times, speaking about assault, because as I said here, they are distinguished. So you want to note that so that your examiner can see that you know that although they coincide with each other, and though some Caribbean countries especially might have legislation dealing with assault and battery together, they're actually distinguished, and case law has proved that. And because the legal question or my issue is based on battery, I went deeper into battery and what the principles governing and the principles that govern battery. So you want, and then because I know based on my facts that there might be a question of whether this was a substantial touch or with whether it could amount to battery, I ensure that I went into the principles that talk about the fact that battery, if it's something that's done in everyday life, then it can't amount to battery. So I'm going to show you how I would apply this question. So application of principles to issue 1. So your application, for me, I put that is the most fun part, and I really think so, because as I said, if you have all your principles, which is why your principle should be compact. This is why your principle should have everything. Because if your principle is compact, your application becomes fun. Meaning you're literally just applying your principles to your facts. But if your principles are not compact, you will find that your application will be stressful, because you will need to start writing some of what the judges said and going deep into what the judges said in your application. And that caused a lot of us in Cape and in our first year of university, where we found that we really did not understand the IRAP method. So we didn't understand that our rule had to be compact and our application was to be simply applying our principle to our facts. So as I have here, well, all you're required to do now is to connect your facts from the scenario to the rules that are listed above. However, if there's an objection to your principle, you must look at whether it can be connected to your facts and note it under application. So I have here, the principle above is that battery is causing, it shouldn't be the contact, autocorrect was giving me a problem, but it's causing contact to the claimant without his or her consent. This is present in the current case where Adam would have tapped Calvin without his consent. However, the objection to the rule explained in Donnelly is that if the contact is of a trivial nature or something connecting to everyday life, the claim of battery will not be actionable per se, and the claimant must prove that this is battery. I do not want this to be a session where I'm just doing all the talking. So you will find that I may not complete all your applications for you. I may have some questions so that you guys can explain, because, well, law is somewhat like literature. I want you to understand that and listen to it in context. Somewhat like literature, where every time you hear literature, there's no right or wrong answer once you can prove your answer. It's the same with law. I can say yes and you can say no. What matters is that when you apply the law to your facts, you can prove your answer why it's yes or no. So I did not really come to just give you my answers and to just say, oh, this is the case. I come to give you the law and for you to interact with me during application sessions, because I want you to understand that we might not have the same answers. The law can change. You can't change the law. But just as though you have prosecutors and you have defense lawyers when you did criminal law, you understand that there are two sides to the law, right? So one person will be saying yes and one person will always be saying no. Meaning, so you need to use the law now to your advantage to defend whether you're saying yes or you're saying no. So in the current case, would you say that he can prove that a simple pat on the shoulder constitutes battery? Anyone wants to go ahead and answer that? Guys? Hello? You can also type in the chat if you don't want to come on the mic or if you don't want to open your cameras. All right, well, in my view, I would say no, it's a trivial matter. And why I would say it's a trivial matter is, well, he was probably just trying to get his attention, or well, her attention, because he assumed that it was a female, his ex-girlfriend. So if we're all in a space right now and something falls from you, I might just tap you on your shoulder for you to see that your pen fell or something of the sort. It cannot be said that it's battery, because that's something that happens in everyday life. If we're in a space, if we're in public and I see somebody that I know or I think I know, the first thing I'm going to do is touch them, or I might accidentally brush past you. You're going to say that everything that I do that is of such a small nature, like that can happen to anybody at any time, is battery. That wouldn't make sense, because if that was battery, then we would have millions of senseless cases in court, because it's something that happens every day and it's something that might just happen to anybody at any time. So I would say it's a trivial matter, and then I will conclude. And I would apply it to the principles of the that I have. So as I said, you might say, and you might have a different answer. As long as you can apply your facts to your rule and prove why that's your answer, I cannot say your answer is wrong. That would be left to the examiners. All right, so conclusion. I have here that you will have more than one conclusion, and this is because in the IRAP method, it's not like an essay where you write everything and then you wrap up in your conclusion. Here, the IRAP method, you must conclude after each issue. So after issue 1, you must conclude issue 1. Because there may be a case where with issue 1, you may have to be advising Adam, and then issue 2, you might be advising Calvin. You don't know. So you must wrap up after each issue. And then after you complete all 4 issues, you must have a general conclusion that sums up all of what you have discussed before. So for your conclusion after this specific issue, a person who marks your exams advised me of this. She tutors me at UE, and she says an easy way to conclude that you don't have to burst your brain. So she said that an easy way for you to not stress out or to go mad because a conclusion is literally just about 2 marks, if it's that much for one after the specific issue, and it's scripted, meaning as long as you have a conclusion, you are going to get a mark. It's not like in university where our lecturers are emotional, and if they just feel like you don't make sense, if your conclusion don't make sense to them, you're not going to get a mark at all. In CAPE, once you have in conclusion and you write something, you might not get the full mark if it doesn't make sense, but you might get a 0.5. You understand? So you have that to your advantage. But to help you to get your 1 mark if it's 1 mark, or 2 if it's out of 2, she said that it is the end of your problem question and your issue statement, and the end of your issue statement. So you must ensure that your conclusion if it says advise Adam, you must ensure that your conclusion has in advising Adam, or yeah, something of that sort. Adam is advised, something to show that you are advising Adam because your problem question said you should advise Adam. And end of your issue statement. Whatever is in your issue statement must come back in your conclusion because you literally just answered the issue. So how can you answer the issue and don't have something in your conclusion that exemplifies the issue? It wouldn't make sense. So for example, I have here, in conclusion, in advising Adam, but as I said, you can have Adam is advised that he would not be liable for battery because of his gentle tap on Calvin's shoulder due to its trivial nature. You might write something else. It's up to you. Your conclusion is what you feel should be there, and you should work according to the time that you have. But as I said, ensure that it has something from your issue statement because that's what you just answered, and ensure that you advise the right parties. Oh, another tip I want to give you. You get rough sheets in your Cape books, right? I think in your booklets. I want you to ensure that when you are writing, you write the name of each party. But to tell you why. I got a B+ in a subject in university, and I know I could have gotten an A. But they had cut down the time on the online exams, and I was really frustrated. And I wrote 2 questions, and I feel like the teacher was just awful for putting 8 issues in each problem question. And when I got to the last one, I was drained, and I had like an hour left, and I mixed up all the parties. I mixed them up. I made some mistakes, and so even though she had to mark the question, I didn't get full marks of the question simply because I advised the wrong persons, because I mixed up their names. So one thing you want to do in a problem question is to write the name of your parties so that you don't make that mistake, because you will lose heavy marks for it. So the second issue that I have on the principle is whether Adam's tender kiss on Calvin's cheek constitute battery. I have battery does not have to include any physical harm to the plaintiff. Therefore, the plaintiff is not required to suffer a broken arm or dog bite. Sorry, someone's mic is open. Hello, someone's mic. Can you please mute? Thank you. Our dog bite, sorry. This is because battery does not have to be a hostile act, as according to Lord Gough in F and West Berkshire Health Authority, the fundamental principle is that every person's body is inviolate. He agreed with the judgment of the Divisional Court in Collins and Wilcock, which explains that the effect of this principle is that everybody is protected not only against physical injury, but against any form of physical molestation. He confirms the general rule that battery is touching someone without their consent, unless there is some substantial public interest in which consent would not be required. Lord Gough also developed the principle which states that any contact out of anger was battery. In developing the principle, he explains that a prank that gets out of hand or an overly friendly slap, though they are not hostile, amounts to battery, as touching another's body in the absence of a lawful excuse is capable of amounting to a battery and trespass. In applying Lord Gough's ruling in F, and so for application of principle to issue here, I have in applying Lord Gough's ruling in F and West Berkshire Health Authority to the current case, it appears that Adam would be liable for battery after gently kissing Colin on the cheek without his consent. This is because, according to Lord Gough, the act does not need to be hostile and does not need to leave the claimant in any physical harm. He explains that an overly friendly act can also amount to battery. Therefore, the fact that it was a tender kiss is irrelevant. What is relevant is whether the act was without the claimant's consent, as according to Lord Gough, the general principle remains that any interference with the claimant's body without his consent amounts to battery, unless there's some overriding public interest for which consent may not be required. In the current case, Colin did not provide such consent, and the fact that Adam believed that Colin was his ex-girlfriend is irrelevant because there was still no consent. And the principle has been developed and explained in a text by Winfield and Jollis, which highlights that kissing a woman without her consent is one such non-hostile act which amounts to battery. Thus, Adam may be liable for battery. Let me conclude. In conclusion, Adam and Calvin are advised that Adam's tender kiss on Calvin's cheek would amount to battery, as the act was done without Calvin's consent. Any questions before I move on to the third issue? Okay. All right, so the third issue, whether Calvin's response of throwing a punch at Adam after the unconsented kiss can be considered a valid defense. All right, so in my principle here, you will see some examples. If your teachers have told you anything different, you can let me know, because I did CAPE about 2019 was my last time doing CAPE, so about 3 years or almost 3 years ago. When I was doing both Unit 1 and 2, I was advised, and I did use it in the exams, and it did help me. I was advised that if you cannot remember the case, do not write in a decided case. You can use examples. You're allowed to use examples. We can't do that. We can't really do that at university. Even if we use examples, if the example cannot be one that's connected to a case, you must write the name of the case and you must write the important principles from the case. But I know in CAPE I was given leverage. I'm not sure if it's still with your year to use examples. If you can use your examples and you remember your examples well, I encourage you to use your examples. You might not remember all the names of the case. And for some of the rules, there might not be a case that outright state either. So if you can remember examples, use your examples. You will get a mark for your examples. You will not get a mark for saying in a deciding case and not remembering exactly what's in the case or the name of the case. So I have here whether Calvin's response of throwing a punch at Adam after the unconsented kiss can be considered a valid defense. An assault or battery is justified if committed in reasonable defense of oneself or another. However, the principle governing defense against assault and battery is that it must be done during the attack and not as a retaliation after the act. Secondly, self-defense or defense of another must be reasonably commensurate with the attack. This means that the response must not be worse than the attack. And here I put an example. Thus, if C punches D, D must retaliate with a punch or something of a less serious nature. He cannot bring a gun into play. This principle was explained, but I put an example and the case. If you can't remember the case, do not talk about it. Your example is fine. This principle was explained in the case Cook and Beale, which notes that a man cannot justify a maim for every assault, as if A strike B, B cannot justify the drawing of his sword and cutting off his hand. But it must be such an assault whereby in probability the life may be in danger. The principle was further developed in the Trinidadian case of Budu and Campbell, where Jamadar emphasized that the onus of proof is on the defendant to demonstrate that his belief that he had to act in self-defense was both honest and reasonable, and secondly, that the action taken by him in self-defense was reasonable having regard to all the circumstances of the case, including the fact that the act of self-defense was taken in the heat of the moment. Application. Throwing a punch would place a person in immediate fear of battery. Thus, it would amount to an assault. because that's the natural principle of assault. So you must identify in your application what the natural or what the original or traditional principle is. However, remember I said you must always identify your objections. This is because it helps in your application. Think of application as a debate. What one person says versus the other. What one judge says versus the other. What one case says versus the other. However, there are defenses in a case of assault and battery, and the principles above must be applied to assess whether Colin can rely on such defense. Firstly, the response must be during the attack and should not be a retaliation. In the present case, the facts state that after the kiss, Colin screamed and threw the punch. I want somebody to interact with me here. Question. And you must ask yourself different questions in your application because it will help you. Do you think this was during the attack or after, or was it a retaliation? Was it in the heat of the moment? I would say yes. But if anyone else opposes, we can have a conversation. You can also type in the chat.
I agree that it was in the heat of the moment.
Yes, because all right, sorry. Yes. I say it's in the heat of the moment because it's not like,
Aspirator for just making it air out of it.
sorry. Someone's mic is open. I said it's in the heat of the moment, given the fact that it's not like Adam left and then returned, and that's when Colin decided to punch him for trying to kiss him earlier in the morning. As he kissed him, he screamed and he threw the punch. So it was right at that moment. So for me, it was in the heat of the moment. It's in conformity with Jamadar's statement. And so in the case that was highlighted above, Boudou and Campbell, and therefore I believe he would have a defense. But there's a second part. So let's look at the second part. Secondly, he must satisfy the second principle, which is laid out in Cook and Beale, which says his response must be proportionate to the attack. And according to Jamar, and in the word in should be there, in Boudou and Campbell, the onus of proof is on Calvin to demonstrate that it is his belief that he had to act in self-defense, and it was both honest and reasonable, as well as he must prove that self-defense was taken. The self-defense that was taken was reasonable given the facts of the case, and that it was taken in the heat of the moment. I didn't have to put back the heat of the moment there, so you can just ignore that part. My question to you: do you think a punch is an appropriate self-defense for a kiss? And if not, then what would be an appropriate way to defend yourself if someone kisses you against your will? It's easier if we see a case where someone punched somebody and they take a gun and point at them, or if they take a sword and point at them, because right there and then we know that if somebody give you a punch, it's a punch for punch, an eye for an eye, tooth for a tooth. Whatever happens there, you do it back. Someone slap you slap him back. But when somebody kisses you, it's a little more technical. So I really and truly did not do this part for you because I really want you guys to explain. So I was hoping that someone would respond to me, that we could have a discussion here. So if someone kiss you without your consent, sorry, what do you think is an appropriate response for that? Do you think a punch is appropriate? Or a slap, something of that sort? Anybody?
I would say a slap or a shove would be more appropriate than a punch because that seems more violent.
Exactly. I agree with you, but is there anyone else that have anything else? I see something in the chat. Slap would be more appropriate. I think it depends on the person actually seen, as everybody have their own reactions. But for me, a slap would be much better. Zidane says if done abruptly, yes, it's reasonable to me. And you see, this is why I did not want to answer the question for you. I really think a slap would be more appropriate as well, but it's really based on how you see the facts and how did he kiss him, and one thing we need to notice. Oh, someone, Cornelia, sorry if I
Yes. Good
go
morning,
ahead.
everyone. But miss, you see that he punched the person, miss, wouldn't that be like he had a moment of clarity where he stopped and said, he had a moment of clarity where he realized that this person kissed me and he was like processing, what should I do now, miss?
Yes, I think so, because he actually screamed.
Yeah, it
And
seems
then
so, miss, so the punch would
yeah,
be inappropriate for the situation right here because he
exactly.
realized what happened and he chose his action to go with what happened, miss. So a punch would be a little overboard.
Exactly. I think so too. But then one thing I want us to look at as well is jurisdiction is important. And I should have said this at the start of your problem question. Please identify your jurisdiction. I don't want to say it's always safe to use Jamaica. I do that because sometimes it's much easier, but I remember going into an exam last week and I had to use Trinidad because Jamaica did not have any statutes and Trinidad had a lot of statutes, and it made my question better for me. So I used Trinidad. But jurisdiction is important. Why? Is because if a man kisses a man in America on the cheek, it may not seem like a problem. But if you do the same in Jamaica, I don't know. That's that, because Jamaica is a, we do not really tolerate that kind of behavior. A lot of men don't tolerate that behavior. They don't like it. And I don't want to go too far because we're doing law and we have to be in context. I want to be careful. But I know that in Jamaica, the response to a man kissing a man would be different from America, because Jamaica don't really, a lot of Jamaicans, let me say, some Jamaicans don't really tolerate that. So given that you know this information with your jurisdiction, as a man, put yourself in his shoes. As a man, as a reasonable man in a Jamaican society or in a Caribbean society, rather, Barbados or Trinidad, would you think it was reasonable for a man to throw a punch or even a slap or anything to someone who would have kissed him on the cheek? Because you're a man and you don't support men being with men, and you're in a country that don't really support it either. Do you think his punch was proportionate then? Or would your answer be the same? Can type in the chat, remember. All right, so there are no answers there. I really think, because I remember doing remember doing something like this in Cape. I think it was probably in another area though. And I remember my Cape teacher saying that it is always important to look at okay, someone typed in the chat. Cornelia says, given the jurisdiction, the punch would be appropriate. Yes, I remember doing it in Cape, and my lecturer said we should always, sometimes they give you these little things to throw you off, because I'm like, why in heaven's name would you all write a case to say he thought it was his ex-girlfriend and then it turned out? So instead of saying it's another woman, they ensure that they made it clear that it was another man. You can see that Cape is getting at something here. And this is because they want you. And I remember doing it in criminal law as well, in university, where there was a question like that as well, where men have different emotions, men respond differently to different things in jurisdiction, different jurisdictions. So based on your jurisdiction, the court might take into consideration that the man might feel like, you really disrespect him, because if he walks down the street, the entire community might start calling him, something that he doesn't appreciate. And that might raise some stigma on him for a very long time. And so we learned in criminal law and in tort that when it's based on the jurisdiction, based on how men would normally react in that jurisdiction, you should use that to guide your answer. So I would say a punch is appropriate, given that if I'm using the Jamaican jurisdiction, a man kissing a man it's a no-no for most men. So that would be my conclusion. But you can argue it differently. And you can say a slap is more appropriate. Therefore, I didn't write a conclusion because I want you guys to understand that when it comes to issues like these, this is where you get to the meat of the matter. They're very complicated. It's where the debate gets hot and or answers may be different. So I didn't write a conclusion because I wanted you guys to understand that, you know, or answers may be different. And I don't want you to go in and see a question like this and you say, oh, I said this because listen, as I said, everybody might have a different reaction to a question. Because for me, law is somewhat like literature where once you have proof, there's no wrong or right answer. But of course, in conclusion, it would just be answering whether you say yes or no, and you would be advising Colin. So issue and principle number 4. I think I didn't write the issue here, but I think mine was whether his words, I think the issue was whether his words that he used that says, if I catch you, you'll see, whether it was enough to actually amount to an assault. So I have here, the traditional rule was explained by Holroyd J. in R. and Mead and Belt. He said that no words or singing are equivalent to an assault. However, the law regarding this area has been substantially developed. And remember, I said originally when I was talking about rule, that wherever there's any developments or anything that overturns the law or the original law or the traditional law, you should make note of that because that's really how you're going to answer your question. If you don't look at that, then it really don't make sense to do the application, to be honest. The modern view is that there will be an assault if the words are sufficient to put the plaintiff in reasonable apprehension of battery. This was explained in the case R. and Ireland. In this case, the defendant admitted making numerous telephone calls to 3 women and remaining silent when they answered. He contended that the facts of the case did not amount to an assault, as a telephone call could not be an assault. The House of Lords dismissed his argument, holding that the making of a telephone call followed by silence or a series of telephone calls was capable of amounting to an assault. They held that it did not matter whether words or silence ensued, since calls of that nature were likely to cause the victims to apprehend immediate and unlawful violence. However, while many cases have rejected the decision in R. and Mead, the leading principle from the case Tuberville and Savage is still applied in many of the modern cases. The principle is that if the words are phrased in such a way that negatives the threat that the defendant is making, it will not be assault. In other words, there must be fear of immediate battery, and the battery must be able to take place. So in this case, the defendant placed his hand on his sword hilt and uttered to the victim, "If it were not assize time, I would not take such language from you." This was held to not be an assault as the assize judge was in town. Thus, there could be no apprehension of immediate force. This must, however, be distinguished from a case where there will clearly be an assault, such as in Reed v. Coke, where the defendant stated, "If you don't give me your money, I will break your neck." The common bench, dismissing his appeal, held that to constitute an assault, there had to be an attempt coupled with an act denoting ability and an intention to assault. Accordingly, there had been no assault in respect of that offense. Sorry. Application of principle to issue 4. Sorry. It is evident now that words can amount to an assault. However, the words must be able to put the plaintiff in reasonable apprehension of battery, according to R. and Ireland. In applying this principle to the facts of the case, Colin, after throwing a mist sponge, shouted to Adam, who ran, if I catch you, you'll see." It is clear that some form of application of force would happen, and therefore it could be said that Colin's words were enough to put Adam in reasonable apprehension of battery. However, the principle in Tuberville and Savage should be must be applied. This principle indicates that if the words use negative the threat, there's no assault. In other words, if there can be no battery, there is no assault. So in this case, the assize judge was in town. So the use of the words, if it were not assize time, negative the threat. My question to you, if I catch you, you'll see. Do you think there is a possibility of Colin actually catching Anna? And this will make your application more effective. Remember I said it's based on what you think or what you see. For me, he can catch it. You know the term you can run, but you can't hide. If they live in the same community and he runs for about 10 minutes, I am sure at some point he will get tired and weary. And therefore, Colin will catch it. And Colin said, if I catch you, you'll see. I believe if he can catch him, and when he catch him, he will actually give him the punch. Whether he's weak or tired or weary, he will give him the punch. Because I'm a man and you kiss me. That don't work. Right? I'm a man, you're a man, you kiss me, that don't work. I know that he can catch him. And if he catch him, he will beat him or punch him or whatever. And therefore, the words for me could be an assault because he can catch it. But if you have a different interpretation, and I want to wrap up because I know it's almost 11 and the other person is going to come now. But I know that if you believe that he can catch it, for example, I don't know how far he can run, but if you believe he can run so far and Colin can catch him, then the words would not actually amount to an assault because he can't catch him. Right? He can't catch him, and if he can't catch him, he can't hit him, and then there would be no battery. There will be no battery could take place. And as we have seen in Tuberville and Savage, once no battery can take place, then you can't, there will be no assault. So, I mean, if it's a case where, I text you, I'm in Jamaica and you're in USA, I don't have a passport or a visa, and I text you that if I ever catch you, if I could come over there and give you a slap, I would give you a slap. Or it can't work because how am I going to reach to the USA if I don't have a passport or a visa? So I can't slap you. It's not possible. Therefore, there will be no assault. But in this case, I believe you running as a human being, you're going to get tired, and I'm going to catch you. And when I catch you, I will give you the punch that you so deserve. However, I didn't write a principle, a fifth principle, but I believe, you should always make your problem question flow. And I think if you have an answer that yes, he will catch him, and yes, it will amount to assault, you will probably need to have a question that follows that say whether he can actually rely on self-defense for that. Because, I mean, well, of course, no, because, I mean, he would have run gun all along. He would have gone, and then it's after you catch him, hours after, whatever you decide that you're going to punch him, then it wouldn't be, it would be a retaliation, and it wouldn't be in the heat of the moment. But I didn't put it here, but as I said, if your answer is yes, it must be there. If your answer is no, then you probably don't have to include it, or you can include it, and I'm sure you will get marks for it just the same. So I have 2 minutes to spare. All right, so I'm going to stop here, and the other person, it's not Shanoya, but someone else, because Shanoya is unavailable, but she did send her notes and she did help us with the presentation. So someone is going to present in her space for her, and she will come on. I'm not sure if she's here already. I'm not sure if she's here already, but she's going to come on and she is going to carry you guys through, I think, strict liability, vicarious liability, and occupier's liability for about 2 hours. You guys can take a break at 1 o'clock, and then you guys see, or 1:30, probably about, and you guys see me back at 2 o'clock, where I will go through 2 real property questions, co-ownership, and I will also go through chattels and fixtures. So she's going to come 10-minute break. Okay, so a 10-minute break now or after she comes on? No. Okay, so you guys can take a 10-minute break now, and then you will return at 11:10, where the other person will come and she will go through another tour, well, about 2 tour questions, and she will also go through a contract question, and I will come back and go through the real prop questions. Someone has their hands raised, we can go ahead. Tyrese?
Yes, miss. Will this be streamed on YouTube?
On YouTube, no, but it is being recorded. So I think you can contact New Jamaica, or you can probably type in the group. It will be posted. Okay, so they said it will be posted. So you will get the recording afterwards. And they said in the chat either today or tomorrow. So you guys can take your 10-minute break now, and then when you come back, someone else will be here to take you through another short question or two, and as well as the contract question on terms, and then I'll come back later to do the real property question.
Okay, so good morning, everybody. I am Anna-Phebe Welsh. I am a second year, going into third year law student at the University of the West Indies, Cave Hill. And I'll be doing reviews for the topics of vicarious liability and contract law with you. I'll be sharing my screen, so just give me a minute. Okay, are you all able to see my screen? Just one person could unmute and let me know.
Yes, miss.
Okay, wonderful. All right, so I'm just gonna run through a problem question with you. I'm gonna quickly state the facts of the case. Randy, the school's messenger, is assigned a motorcycle to enable him to perform his duties. On a rainy day, Randy is on his way to the board chairman's office when he diverts to the bank to pay his daughter's school fee. He is riding into the bank's compound when he collides with and injures Martha, who is rushing into the bank to get out of the rain. The school denies liability for Martha's injuries. Randy thinks this is unfair. With reference to decided cases, advise Randy as to his liability in torts, explain to him whether or not the school's position is an acceptable one. So as you should know, problem questions are normally the heavier ones. So this is like 25 marks. So you would use the IRAC method. You should be familiar with the IRAC method. All right, so the issue here is whether Randy should be personally liable for Martha's injuries or whether the school as Randy's employer should bear liability for Martha's injuries. Okay, so in your rules section now, you could state what vicarious liability is. You don't have to, but you can. Just to let your rule flow from definition to the elements. All right, so there are 3 elements that you need to present for vicarious liability. The first one is that the person who committed the tort must be an employee. So this is important as the employer. Hello? Okay, this is important, and as the employer is generally not liable for torts, generally liable for torts of an independent contractor. So you know that there is the employee and there is independent contractor. So you would have to now state what the control test is. And this was held in Collins v. Hertfordshire in 1947. So you'd briefly state what was held in the case, which is really in summary, the employer controls how for the employer controls how he is to execute his duties versus the independent contractor, which is not bound by the restrictions of the employer. So to build on your law, which will give you extra marks, you can say the evolution of the law in relation to commercial businesses. So we're in Market Investigations Limited and Minister of Social Security. Other factors to consider when determining who is an independent contractor, you will consider, does he provide his own staff and tools? What level of financial risk is taken? And the degree of management that he's able to exercise over the task given. So if these factors are absent, then he's an employee. He or she is an employee. You could also make reference to the case of Harrison Hall, which you don't have to, but if you want to, you can expound and build your law section. All right, point 2, or element 2 rather. A tort must be committed. So this is where Martha would have to now prove that Randy committed a tort against her. The principle in Young and Box and Co. Limited 1951 states that the master is liable for the servant's action okay, let me go again. The principle states in Young and Box and Co. Limited that for the master to be liable for the servant's action, the question is whether the servant is liable. Okay, this is wrong right here. I'll have to fix this. So let me just make a strike through. All right, so Martha has to prove that Randy was riding recklessly or negligently, which resulted in her injuries. Give me 1 second, let me make the correction. Young and Box. Okay, so for Young and Box, this is the correction. To make a master liable for the conduct of his servant, the first question to ask is whether the servant is liable, right? So point 3 now, which is element 3, the tort must be committed in the course of employment. So now to determine whether the course of employment was in action, it could be an express or implied action, which is authorized by the employer. It could be an authorized manner of doing something authorized by the employer, or it could be incidental to the task that the employee does. Incidental meaning on the way or in the process of carrying out the act, he had to do something else to fulfill that act. So in your application section, now, you would go back through the steps or through the elements one by one and apply the rule to the facts of the case. So is Randy an employee? Yes, Randy is an employee. Why? The facts do not state that Randy supplies his own tools and staffing. There is no indication of the undertaking of a large financial risk. And considering the principle in marketing investments, so you would wrap that sentence by saying, considering the principle in marketing investments, Randy would be an employee. For element 2, Martha may be able to establish that a tort was committed. Yes, she was hit down. Element 3, which was the tort must be committed in the course of employment. So it is key to note here that the school will not be liable for the tort if it occurred outside of the scope of Randy's employment. So going back to the 3 steps here, none of the 3 steps can be proven. So Randy was not authorized to divert from his route to go to the bank, and it cannot be said that he was performing his task in a manner authorized by the school, nor was the bank incidental to him carrying out his task by going to the board chairman's office. So if Randy was not acting in the course of employment, it could be said that Randy had gone on a frolic of his own. So what is a frolic, or what is a frolic of his own? In Joel and Morrison 1834, the court held that when an employee greatly deviates from the route and task assigned, then he has gone off on a frolic. And you could further mention that Joel and Morrison was adapted in the case of Dunkley and Howell, which is a Jamaican case, and this will build your analysis. Here, you can just briefly state the facts of the case and what was held. So in conclusion, you can say Randy has established element 1 and 2. However, he has not established element 3. So therefore, he was on a frolic of his own. This, as a result of this, he will be liable for Martha's injury and the school will not be liable. So was that clear, everybody? Any questions on that?
No, miss, no questions.
I know it was a bit jumbled. I'm a bit nervous. This is my first time teaching. So let me just quickly run through that again. For vicarious liability problem questions, you state your issue, and your rule section, you would state what vicarious liability is, and then you state your 3 elements. And don't forget your cases. You have to have your cases, you have to know your cases. So you state what vicarious liability is, you state the 3 elements with case references. That's your rule. For your application, you will break down each element step by step and see whether the facts of the case line up with the element given. Then you would ask like yes or no questions Is there a tort? Yes or no? Is he an employee? Yes or no? Was the act committed in the course of employment? Yes or no? And based on your answer, you will come to a conclusion. Is that clear? Everybody
Yes.
clear?
Yes, miss.
Okay.
Yes, miss.
All right, so we won't be doing occupiers liability. Okay, for contract law. Contract is, or for most law questions, it's really a step-by-step process. So if you know your elements and you know your cases, you really should be fine. It's like a checklist. Contract is one of those topics. Question 45A. With decided cases, outline 4 ways which an offer can be terminated. So here, first thing you would do, state what is an offer. This is a 10-mark question, so you don't have to go very in-depth. Just keep it clear and concise, get to the point, okay? What is an offer? An offer is a clear, unequivocal, and definite promise to be bound, provided that certain specified terms are accepted. Excuse me 1 minute. Okay, sorry about that. So you state what an offer is, which is a clear, unequivocal, and definite promise to be bound, provided that certain specified terms are accepted. Then you would go on to state the methods of communication of an offer. An offer can be communicated written, orally, or by conduct. The methods of termination, revocation, rejection, lapse of time, and illegality. And you must state, and this is very important, termination must take place before acceptance of the offer. So if the offer is accepted, then you can terminate afterwards, right? So revocation. And revocation is a method of termination of an offer by the offerer. And this may be express or implied. And this was seen in the case of Brian and Van Teenhoven, 1880. Let me quickly pull up the facts for this case. Okay, so in this case, VT wrote to B offering goods for sale on October the 1st. He then withdrew the offer by letter on October the 8th. B, the plaintiff, received the initial offer on October 11th and the revocation letter on the 20th of the same month. Here, the court found that the offer had not been revoked as it had been accepted before the receipt of the proposed revocation. So as stated before, the termination must take place before the acceptance of the offer. If the offer is accepted before the offer is withdrawn or terminated by whatever means, then you have to go follow through, right? Implied revocation. So implied revocation is where acceptance of an offer by a third party prior to the acceptance of the offer by the original offeree. So, okay, let me break this down. So if A makes a contract and B proposes to accept, if C then accepts the contract ahead of B, then that's an implied revocation to B. Does that make sense? You can use the chat, guys, if you don't want to speak. You can use the chat because else I can check.
Sorry, miss, could you repeat?
Okay, so implied revocation. This is an acceptance of an offer by a third party prior to the acceptance of the offer by the original offeree. So if A makes an offer to B, right? But C accepts the offer instead, then the offer is revocated to B. So B would no longer be the offeree. Is that clear?
Yes,
B would
Yes,
have-
Miss. Clear.
Right, so B would have been the original offeree, but since C has accepted the contract, then it's revocated, right?
Miss,
Yes.
so was that like a situation where there was a lapse of time?
No, lapse of time is different.
Oh,
Lapse of
okay.
time is different. We'll get to that shortly though. All right, so in Dickinson and Dodds, I'm just gonna briefly go through the facts of the case. The defendant offered to sell his house to the plaintiff and gave an undertaking that he would keep the offer open until Friday. The defendant, however, sold his house to a third party on the Thursday before the offer was to expire. The claimant, hearing news of this, purported to accept the offer on Friday morning. However, the offer was effectively revoked as there was no obligation to keep the option open until Friday because the original offeree had provided no consideration for the option, which would have served as acceptance of the offer. So if the contract is if the offer is left open, anyone can accept it, even though you had put in a word to say you're considering taking the offer, right? Is that clear? It makes more sense? Hello?
yes, it does.
Okay. All right, so rejection. It's another method of
Yes.
termination. Yes?
Sorry, Miss, but are you going to go over consideration?
You know, I had not gotten to that point, but I can try to attempt it with you guys.
Okay, Miss.
Okay.
If you can. Thank you.
Yes, no problem. Rejection is another method another method of termination, and this takes place by the offeree. It may be implied or expressed. Rejection may be done by way of counter offer by the offeree. And a counter offer is where an attempt is an attempt by the offeree to alter the terms of the original contract. So if I make an offer to my brother and my brother says to me, he wants to alter term 2 or term 3 of the contract, that's a counter offer because he's attempting to change the terms of the original contract. Okay, all right. In Hyde and Wrench, the defendant had offered to sell his farm for £1,000, but the plaintiff informed him that the plaintiff, would pay £950 instead for the farm. This counter offer effectively terminated the original offer. So you see where the plaintiff here was trying to pay £50 less for the farm. So that's a counter offer, right? Acceptance must mirror the offer. So this is key to note. Acceptance must mirror the offer. It is important that it is an important rule of contract that acceptance must mirror the offer. That is, the terms of the proposed contract must be accepted in the same manner as they were offered. So if I state A, B, and C, you should accept A, B, and C. And if you make a counter offer to say A, B, C, and D, I must accept A, B, C, and D. Is that clear?
Yes, Miss.
Okay. Okay, lapse of time. Lapse of time occurs by a fluctuation of time or death. This also occurs where it is impossible to fulfill the term of the contract. And this was seen in Taylor and Caldwell. And this is a very key case to note. Yeah, so lapse of time, really simple. If the offer stands for 3 days and the 3 days have passed, then lapse of time has passed, right? Illegality, which was stated further up, that speaks for itself. If the contract goes against the law, then it's invalid, it makes no sense, all right? Okay, 45B. So this is any questions on that before I move on to the problem question? Anything that's not clear? Okay, so we're all good then? You can use the chat, guys. Okay, I'm gonna move on to the problem question then. All right, so Donna's pet dog, Flash, is missing. On March 20th, and please pay attention to the words that are in red. For contract law, dates are very important, extremely important. So you have to pay attention to dates. Donna's pet dog, Flash, is missing. On March 20th, she puts up posters in her neighborhood offering a reward of $1,000 for Flash's return by March 25. She also advertises the reward for its return in the local newspaper. On March 23, Donna decides that she does not want Flash anymore. On the next day, she publishes an advertisement in the newspaper withdrawing the reward. Evan finds Flash that same day and sends an email to Donna claiming the reward and informing her that she can collect Flash from his house. Donna opens the email on March 26. Is Evan entitled to the reward? Support your answer with reference to case law. And this is a 15-mark question. So to help you out, what you can do if you have a question like this is you try to draw like a timeline. So put the dates on the line at points and say, okay, this happened on March 20th, this happened on March 23, this happened on March 24, March 25. So it will make much more sense to you. And it will also help in the application of the law. Okay. So the issue here is whether Donna's posters and advertisements in the, well, there are three issues, but we're gonna start with issue one, right? Whether Donna's posters and advertisements in the local newspaper constitute a valid offer. So in looking at this now, you would say, okay, an offer is made, what type of offer is it? So this is a unilateral offer, it's a one-sided promise, and there is no exchange of promise. So it's not bilateral where there's a exchange of promise between myself and another party, where I promise to do something and the party promises to pay me, which is consideration. None of that here. Donna says, if you find the dog, bring the dog to me and I will give you $1,000. So it's a one-sided promise. Acceptance of this promise here happens where there's the return of the dog instead of there being an affirmative response. So acceptance here is by conduct. You find the dog, you return the dog, right? The case instructive as it relates to unilateral offer is Carlisle and Carbolic Smokeball 1892. So this is a very important case to know, if especially if you intend to pursue law at a higher level. This case is very important. One minute. Right, so in Carlisle and Carbolic Smoke, the defendant issued an advertisement stating that anyone who used their device and still contracted influenza would receive £100. These facts can be likened to the case. Hold on. Right. So defendant issued an advertisement stating that anyone who used their device and contracted influenza would receive £100. So it's a one-sided offer. If you use my product and you contract the flu, well, I'm gonna compensate you £100. So that's really what it is. One-sided offer. So is Donna's offer now a valid one? Yes. It's a simple question. Yes, Donna's offer is a valid one. All right. So the second issue is whether the withdrawal of Donna's offer was valid. So here, a unilateral offer can be validly revoked but this must be done before the performance of the offer. Before the performance of the terms of the offer. So as I stated above, termination must occur before acceptance, right? And this is in Errington and Errington. So in this case, a father had promised his daughter and son-in-law that if they paid the mortgage on the house he owned, it would be theirs. The couple paid in installments, and shortly before completion of the payments, the father withdrew his offer. Here the court found that the offer was no longer capable of revocation, as his daughter and son-in-law had begun performance of the contract. So is this case clear?
Yes,
Everybody all right?
I think it's
Miss, I'm sorry, Miss, but could you like repeat that last part that you said?
Okay, so I'm going to go back to the facts of the case. We're going to Errington and Errington, Errington and Errington. So a father had promised his daughter and her husband that if they paid the mortgage on the house that he owned, they would have received the house, right? So they started to pay in installments, and shortly before they were about to finish completion of the payments, he withdrew his offer. So the court found here that he could not withdraw his offer, as his daughter and his son-in-law had begun performance of the contract. So because they had already started paying down on the house, he could not withdraw at that point because they had almost already completed the mortgage payments. A bit clearer?
Yes, Miss.
Okay. So this is a bit technical now, because looking back at the facts of the case, Donna had made the withdrawal of her offer the same day that Evan had found Flash. So now we are unclear. We're not clear as to what happened first. We're not clear if Evan found Flash first and then Donna made the withdrawal in the evening. I see that there's a raised hand. That person could go ahead. Kieran Taylor.
excuse me.
Yes.
I was late. I'm not sure as to what you're covering now.
Okay, we're going through contract.
So we're going to cover all the areas of contract law.
Could you say that again? Something was passing by and I didn't hear you.
We're going to cover all the areas of contract law.
No, because I had been given all of this information very late, so I'm not fully prepped. But I could try to go through a few questions with you.
All right, but I
If you have, right, go
may
ahead.
I attempt to answer as to, or try to resolve the contention between the technicality that arose within the given set of law?
Well, the technicalities that I was just speaking about?
Yes.
Okay, so we are not clear as to whether she made the withdrawal first or if he found the dog first. We're not sure. So because of that, we're kind of left in a limbo. So the validity of the revocation, in your conclusion, you would state that the validity of the revocation will depend on whether Evan found Flash before or after Donna's withdrawal. And so with the entitlement reward, which we are not clear on which happened first. The facts just state that both actions happened on the same day, but we are not sure at what times in the day, right?
But what if there is another landmark case that could be used to more lean it in the favor of the person who set the offer out? Right?
So you could use that case. Remember that you're arguing your points, and if you're arguing for Donna, you would have to come with everything to make sure that Donna is in good standing before the court. So if you have a case of similar facts, you would state that in such and such a case, this is what happened and it could be applicable here.
Yeah,
or if you want to make a distinct comparison, you could say in such and such a case, this happened, however, X, Y, and Z, right?
Yeah. The case was Shui v. the United States of America.
Okay.
That a
Anything
unilateral.
that helps your case, anything that helps your case. If it's statute, if it's case law, you use it. You wanna tell us what Shui said?
I was saying that it said that a unilateral offer can be it can be withdrawn using reasonable steps. And let's say the medium that the offer was advertised in was a newspaper. If it
Mhm.
is that the offerer would have used the same steps to withdraw the offer, then regardless if the offeree read the termination, it would be valid, because since the offer is a unilateral offer and made to the world, then it would
Mhm.
be then the onus of the offeree in that sense. So that is basically the principle in Shui for the United States.
Yeah, that's good. You could use that. Very good. Oops. All right, is everybody clear? Did everybody understand what Karen was saying? All right, my co-host, there are two people in the waiting room, so if you could let them in. All right, so the third issue here is whether Evans' act of emailing Donna on the day of her withdrawal constitutes a valid acceptance. Now, you have to know the postal rule, right? The postal rule is some people are confused by it. Some people get it right out the bat. So you need to know it and know what it says. So it is essential to note the distinction between acceptance by post and acceptance by electronic means. The postal rule states that acceptance by post is valid the moment it is posted. So, you know, post would be like actually going to the post office and dropping off your letter in the box, right? Ancient days thing. So, so the moment you post it, so for example, if you had bought the paper and there was a offer in the paper made for like a piece of land or so, and you wrote a letter to drop it off at the post office, the moment you drop the letter off in the post office, that would be acceptance, right? However, acceptance by electronic means takes place when the acceptance is received by the offerer. And remember, the facts state that Evan had emailed Donna, right? So, right. So going back to the dates, the facts state that Donna made the withdrawal on March 24, which was the same day that Evan accepted her offer. But Donna did not receive his email until March the 26th. So what that means, therefore, is that Evan's acceptance is not valid by Donna, as it was received by her after her withdrawing the offer. Is that clear? Hello, everybody understands what's happening there?
Yes, that was clear.
Okay, hold on, let me check the chat. Okay, good. All right, so let me just go back to it again. If communication takes place by electronic or instantaneous means, then the acceptance will be valid when it is received and not when it was sent. So in contrast to the postal rule, where the acceptance happens at the moment that they accept, like the letter or so is posted, by electronic means, the acceptance is valid when it is received by the offerer, okay? Okay, so this is where my presentation had ended, but there have been questions about consideration. So are there any specific questions, or would you like me to go through like an essay question with you? Hello.
Is it Miss? Well,
Yeah, it's Miss. You can say Miss.
All right. Are you being guided by the list of topics that was received by CXC?
Okay, so I'm just filling in for the actual person that should have been here because that person had to leave, and I literally got this information last night. So
So you weren't
I'm
aware?
not fully prepared.
Oh,
Yeah.
but I think according to our list of topics,
Mm-hmm.
we won't be getting formation and discharge of contracts. What we will be getting, however, is
Mm-hmm.
legality and privity. Privity, illegality, and I think since privity and consideration overlaps, particularly the third rule of consideration that we could look at consideration, and we're getting contractual terms and vicarious liability, strict liability, types of land ownership and co-ownership. So
Wow, that's a lot.
that's basically
When is your exam?
it's the 8th of June.
Okay. I'm not fully sure who is in charge, but if I could go and do some revision on it and we could have a next meeting, then that would be good.
All right.
Okay. I would probably have to get some contact information, maybe like for your group chat and so I could like send you guys like a PowerPoint slide with a very compact notes, very compact notes, bullet points and stuff as to how you could go about answering those questions.
That would be appreciated. But
Yes.
we received notes from, I don't remember what's her name, but I think it's the other advisor. We received-
Samoya?
Yes, from her.
Okay. All right. I will talk to Samoya and see if there's anything else that I could do to help you guys out. As I said, I really got this last minute, so I had to rush and do this. But if you guys need any more like help or going through problem questions, let her know and she will contact me, okay?
Yes, yes.
Okay. Right, so this is where my presentation ends. I hope it was clear for everybody. Have a good day, everybody.
Same to you. So
Hi guys, so I'm having some issues with my PowerPoint, so just give me a minute. So I'm trying to pull it. Give me a sec. All right, guys. Good afternoon now. So I am going to, what I'm going to do is I'm going to go through one question and then I'm going to give you guys a short break because the other question, although I have it already dealt with on paper, I need to transfer it to the PowerPoint so that it can be in a presentable format for you. So I'm going to go ahead with the PowerPoint that I have now, and I'm going to go through that question. And then when I'm done, you guys will get like a 15-minute break, 15 minutes the maximum, while I transfer the information for the other question to the PowerPoint. The questions I have to go through right now are one on fixtures, well, one on realty, personality, or well, fixtures and chattels. And then the second one is on co-ownership. I don't have one on mortgage, but I promise you, based on how we're going and how the time is going, if you really have a problem with mortgage, I'd have to look at one of the past paper questions and go through, but I'm not prepared to go through mortgage or easement. So I have to let you know from now. But I will be going through fixtures and chattel and co-ownership. So I'm going to pull up my PowerPoint now. Just give me a minute to share my screen. All right, so just let me know if you are hearing me, one, and two, if you're seeing my screen. You can type in the chat. I just want to confirm. Are you seeing my screen? You're hearing me? Okay, all right, thank you. All right, so I know this is one of those, well, I don't think this area of real property is really one of those bugging areas, but I know real property itself is one of the hard areas that you guys have to deal with. So that's why I chose to do 2 questions from this area, sorry. So the question I chose, I don't really remember which paper it came from. I think it was about 2015 or 2014. So the question reads, Caroline bought an old great house in the countryside because she was excited about the historical painting stuck to the wall and the unusual burglar proofing on the windows. Mr. Harry had agreed to sell her the house with these items, but to her dismay, when she moved into the house, she saw that they were all missing. With reference to 2 decided cases, advised Charlene, on the likely success of a claim against Mr. Harry for removing the items from the house. No, I don't have an issue as to whether the fact that he was supposed to sell her, he agreed to sell her the house with it, means that he has to give it to her, because I don't, remember you have to apply the rule, you have to apply it has to be a legal question and it has to have facts and law. Now, one of the problems for me is that I don't want you to mix your real, someone is talking. I don't want you to mix your real question in a way that make you seem like you are answering a contract question. So I want you to be careful. So if you cannot tie in your issue with something that connects back to real prop or connects back to fixtures or chattels as it is here, don't write that issue. I want you to be careful so that you don't, because the areas can be closed. There are things in, well, for me, at you or contract teacher teaches real prop and a real prop teacher teaches contract, because a lot of contracts tend to be property based. So I want you to be careful of not looking at the agreement so much as looking at the items that are missing and whether those items are actually fixtures or chattels. So the issues I have are that I identified. You might identify more, you might have identified less, but what I see and what I can help you with for now, someone typed in the chat. You'll not be getting fixtures or
Yeah, good afternoon. Yeah, we're not getting those, so I'm kind of confused as to, why you're doing fixtures and shuttles. I understand that we're supposed to have an appreciation of the entire syllabus, but I thought that these sessions were supposed to tap in onto, the specified topics as prescribed.
No, because we have, yes, we have the topics in general, and then there's a syllabus. So something is just very confusing about your year. I'm so sorry. All right, so what are the topics that you will actually be going through? I do have information.
I'm gonna go back to it. All right, so for module 3 real property, we're getting types of land ownership and co-ownership. Yeah, that's all for real prop.
That's all?
Yeah, types of land ownership and co-ownership, that's all.
Oh, okay.
Because Yeah, I don't know. I understand that these sessions were planned from before, and all of them things. But me I say no little amendment, no make and them something. You get what me I say?
No,
Because
I actually do have a question on this, but I didn't know that it was the only topic or the only thing
man.
that you're getting. Or rather, I did not know that they gave you the specific topic. For
Mhm.
my
Yeah,
year, we just
they
had
gave us
to
what from
we just had to
2021 to 20.
run through, and we just never have a choice. So
It's
I'm
because of
so
the whole
sorry.
COVID thing and the late start for school and whatever. So they were just
All
trying
right.
this
So give
late
me a
school
minute. I
decided.
do have the question, but I have to transfer it to my PowerPoint. Is that okay? Can you guys give me like 10 minutes to just transfer it to my PowerPoint?
Yeah, man, no problem. That would be more effective for us.
Okay.
So
All right.
thank you.
All right. All right.
Yeah,
I'm
man.
coming. Yes.
Yeah, yeah.
music for 1 minute. I have a quick question. Did they tell you guys whether you will be getting essays or problem question, or you don't know regarding that fact, or you're getting both? Anyone they choose to give you. So it's like, is it a case where they tell you guys that you're definitely getting problem questions, or they tell you that you will get a mixture of problem and essay questions? They didn't say. Okay, all right, thank you. You can put on the music. I'll be back shortly.
All right, guys, there's a quick question in the chat. You can just answer it quickly, and then we'll continue in about 2 minutes.
All right, guys. Hi. So sorry. Thank you for waiting. So I'm going to do one and then the other. So I'm going to deal with a joint tenancy in common question first, and then I'll move to the other topic. So just give me 1 minute. All right, so I'm gonna share my screen. All right, so okay. All right, so I have, well, we'll probably need to write an essay together. So I'm going to need you guys to participate with me and don't actually leave me hanging, because I am trying to get you guys to understand how to do it. And I don't think that essay question I can just give pointers and leave it like that. I think we kind of have to work together here. And essay questions aren't really my favorite, but because your questions are compulsory, I would definitely have to go through it. And most of the past paper questions that I see on this are actually essay questions. So I want us to go through an essay question just in case one is compulsory. It comes and it's an essay format and it's compulsory. Since as we went through a problem question this morning, if this comes and it's an essay type question, then you will be able to answer it. So types of land ownership and co-ownership, and I'll be focusing on land ownership first. So hold it. Let me set up the slideshow. I didn't realize it wasn't in slideshow format. All right, so what I have here first is the question is to explain the 4 unities of a joint tenancy, which quite likely you're going to get a question like this, and it's going to come at some point or another. To explain the 4 unities of a joint tenancy. And then B, your clients, Mr. and Mrs. Chang Fong, have 10 children between them. He has 5 boys by a previous marriage. She has 3 daughters before she was married, and together they have 2 children. Mr. and Mrs. Chang are seeking your advice on whether they should purchase the High Hill estate as joint tenant or as tenant in common. Explain to your clients the differences between joint tenancy and tenancy in common. Now, I want you to look carefully at section B. And the reason is, I remember saying to you this morning that normally when you see parties or something like that, it might be a problem question. But then the trick is they put at the end, explain to your client. So at the end of the day, it is still really and truly an essay. So you have to look at the words that are there, explain, discuss, as I said before, and know the difference. You have to be able to identify the difference between a problem question and an essay question, because if you write one when you should write the other, you will lose heavy marks for it. So the first thing that we'll look at is, what are the 4 unities of a joint tenancy? So you have unity of possession, unity of title, unity of interest, and unity of time. Now, I placed this before I actually speak about how to write the essay question, because I want you to understand that if they ask a question as straightforward as this, what are the 4 unities of joint tenancy, or if it's a question where they ask what are 3 of this or 2 of this, and you don't have them, then you really and truly, you're not getting anywhere in the question. So I want you to acknowledge this, because as I said, if they're going to give you a question on land ownership, more than likely, you're going to have to answer this. How do you answer essay question? So you have to give an extensive definition. So you remember when we were doing the problem questions, and I reminded you that you have to give a definition, but you can give like a simple definition of 1 or 2. It's different with an essay, because an essay you are actually discussing and explaining. If you're doing a problem question, it's like going to court where you're doing 15 minutes, you have 15 minutes to present, which means you have to get straight to the point and just explain. But if you're doing an essay, you have to give an extensive overview. And again, you have to act like your examiners know nothing about the course and you're introducing them to law for the first time. So the extensive definition of the overall topic includes anything that is separate from the general. So it includes the general principles. Yes, I should have put that there, but it also includes anything that may add on or develop the general principles. So for example, you know there's no joint tenancy without words of surveillance. You have to explain that in your introduction just the same. You have to identify if tenants can sever their joint tenancy, and if yes, how. Because if you don't explain this, then you really won't get to the meat of the matter. So you really won't be able to transition. You have to also use the cases to explain, as you don't have principles without using cases. So an essay is sort of different from a problem question where you can probably get away with some examples. With the essay, you have to go more in depth and you have to be more accurate, because if you don't have those principles, then you don't have the law. And if you don't have the law, then you're not answering a law question. Seriously. So you must have the principles on whether or not tenants can sever their joint tenancy. And this is where you'll be able to make a smooth transition into what the question is really about, which is the important section where you will identify the 4 unities and define them. These 4 unities can actually be your 4 paragraphs, 4 body paragraphs, and then you conclude. Before I go into the other part, section B, we are going to start our essay. Still seeing my screen, right? You're seeing where I am on the Microsoft and no longer on the PowerPoint, right? Okay. All right. So a joint tenancy. Can anyone tell me what a joint tenancy is or what it refers to? Because guys, this is a review session. Really and truly, it's not a class where I am going to teach you. So if you have the information, which I am hoping you do, especially because it's just 2 topics on the real prop, which is really good for you. I had to go through about 6. I am hoping that you guys can help me here and we can write together so that I don't just give you back all the information. I have the information, but I'm purposely withholding it because I really want to see where you guys are. And I don't want you guys to go back into the place and rewrite the essay, and then it probably don't fit your liking, and you probably get marked down for it, because I don't want to be held accountable for that. So I'll guide you as much as possible. But if you guys can give me a definition here, then I can write it. So anybody willing to talk? All right, so Cornelia says this is a division of land between 2 or more people. All right, so that is correct. Give me a second. So question, the next question that I have really is if they do, when you talk about joint tenancy, because you know you have joint tenancy separate from tenancy in common. So when you have joint tenancy, how is your interest shared? All right, so when I speak of joint tenancy, let me see the names that I have here. Give me a second, I'm going to start. I'm not calling you, I'm just using your names as example. So for example, I see JD and I see Malik, right? All right, so if JD and Malik are joint tenants, would it be a case that JD will get 2/3 of the land and Malik will get 1/3, or would it be a case where they would get the land 50-50? So I want you guys to explain to me how, when you are in a joint tenancy, how is it shared? Anybody? I literally just gave you guys the answer. It's literally a multiple choice question at this point. Will I get 1/3 if myself and my brother gets a property and we're supposed to hold it in as joint tenants, or would it be a case where we would get 50-50 if we're holding it in joint tenants? It's literally a multiple choice question at this point, guys.
50-50.
All right, yes, that is correct. So when you have a joint tenancy, you share the land equally. So it's not actually done where each person will get a small part or someone will get a larger part. No, joint tenancy means you have the land equally. So I'm going to write that no. All right, so the next question that I have for you guys is what exactly, because you would have noted that I wrote it here because we're kind of sick for time. So I want to just continue that we can go, we can just go. So I won't ask you every single thing. I will just write some stuff and then we'll continue. Okay, okay, yes, Zidane, I saw your message in the chat. I agree. So what exactly are words of severance? So you see where I have here that where there's a joint tenancy, it means it's conveyed to two or more persons without words of severance. So what are words of severance? Anybody at all? What are words of severance? Or you think about joint tenancy and we say that it's without words of severance. What comes to mind? All right, so where there's words of severance, okay. Okay, yes, thank you. So words of severance is when someone will indicate that each person is to have a different share. Now, because as we have indicated before that joint tenancy refers to where the land is shared equally, it means that there will actually be no words of severance. You have to also indicate that there. So I'll type it, you have to indicate that there because remember, the examiners know nothing. Just remember that in your mind. And if you're explaining to them and you're writing an essay and you're trying to get down to the nitty-gritty, you have to show them every single thing so that you can get a mark for it. And also remember that part B of the question speaks to the difference between the two. So if I'm going to talk about the difference between a joint tenancy and a tenancy in common, I have to explain perfectly everything about joint tenancy and a tenancy in common so that they can understand. All right. So I tell you that autocorrect is very weird. All right, so my next question is whether you can sever your joint tenancy. So if I give, all right, so I have 2 sons and I give my land to both of them. Remember, they would not have gotten the land with any words of severance. So they would have gotten the land in a way where I shared equally. But the next question is if they can, within themselves, 2 of them, can they sever their share? So, for example, A and B both receive property from their parents. Can A sever his or give or rent or lease or do anything to his property to someone else, up with his property to someone else, or with his share to someone else? So can A give a part of his property to C? And can B give a part of his share or a part of their share, sorry, to B? So A and B both inherited the land as joint tenants, but can A give 25% of his 50% to B? All right, Malik. Malik says yes, Camelia says no. All right, so that's one of the things that we have to look at under joint tenancy. This is actually where the unities come in. The unities explain that persons can actually, well, one of the things about the unities is that you can actually comes in when you want to like give another part of your share to someone else. But there are conditions, and the conditions is where we get into the unities. So let me just write it here. Zidane, go ahead. Zidane, you raise your hand, you can go ahead. Hello? Or you can type it.
Am I being heard clearly? I think my internet connection is
Oh, I'm
very
hearing
bad
you now. I'm hearing you
at
now.
the moment. I'm not quite sure.
You can, I'm hearing you now. You can go ahead. What?
Am I being heard?
Yeah, well, you tripped out again, so you can go ahead now. I'm listening. All right, so before I go any further with typing this, Zillian, I'm not hearing you, so I'm going to go ahead and when you come on, you can talk, or you can type it in the chat. Before I go further with this, because I do assume that some of you are confused, one of the things is that when you have a joint tenancy, you're seen as a single owner. So you have a unity of possession, and I'm trying to not go too far into that until I get there, until, you know, so that we can go step by step. But one of the things is that you are a single owner. So I cannot just give a part of my land or sell a part of my land to somebody else without actually without actually speaking to the other person or the other person that I have a joint tenancy with. But it doesn't mean that I can't sever it. It just means that there are certain steps that have to be taken, and we'll get to those steps eventually. Zane, I'm still waiting on you. I'll continue typing. right, so since I'm not hearing from Zidane and it seems he probably left to rejoin. So the next thing that I will ask about, and all of these connect back actually to the unities that we're going to go into, is if I get a property to share with my brother 50-50, and unfortunately my brother passes, can I now claim the land as my own? Or will my brother's children be able to come and claim some part of the land? Or if myself and my brothers, because remember, it doesn't have to be two. We use two to make it a little easier, but it can be 3 persons or 4 persons. Nobody? Nobody at all?
I would say it would depend on the circumstances, because even if you could proclaim that the principle of just acquiescendi would be applicable, then the principle of just acquiescendi also posits that where in a situation such as that one where his children may be remainder men, then you would just be you'd hold the land as a trust for his estate.
Okay, thanks you. All right, and you refer to a Latin term, which is important because I do want you guys to know that if you make note of the names or of the legal terms, you tend to get marks over someone who would have left out the term. Not saying that if you don't remember the term, or if you can't pronounce it, or if you can't spell it, that you will lose a bulk of marks, like 5 marks, 4 marks, but you might lose a mark because it's law, and these are especially property law. And you will learn, if you continue to do law after CAPE, that when it comes to property law, Latin terms are essential, because property law is coming from, Old English, and most times they would have used the Latin term. So it's important. So if you see one there, we ask that you do not go over it, or I would always advise persons that you can use sticky notes and flashcards, so things like that you can always remember them when you're studying. What I want someone to explain for me though is that he used the term a while ago, just acquiescendi. What exactly is the meaning of just acquiescendi? What's the English meaning? What's the meaning? Because I don't want you guys to be writing or thinking about something and you don't even know what's the meaning. Because as I said, I don't know how they will frame your questions, and I want, if you go into the exam, you can actually understand what you're writing. So what is the meaning of just acquiescendi? Right to survivorship. Yes, so that is correct. So what happens is that if A and B both got land from their parents and B dies, then A will get the land, or A has the right to get the land because of this title or this principle, the right to survivorship. Give me a minute. Also, always remember to put your cases in isolate. You can't because you're writing. Forget you're not doing an online exam. I'm so sorry about that. But you can highlight it, you can underline it. When you're writing, normally they tell us that we can put it in bold or italics because we were typing our exams. But for you, you can highlight it or even circle it. I don't know, whatever you want to do, but you need to make sure that they can see that this is the case and this is the principle, this is the law. So I always advise you to you can't take highlighters in your exam or anything of the sort. So I would just advise you to use to just underline or circle something so that they can identify that this is the case, this is the principle, this is the law. All right, so basically, as we would have said before, you can sever your joint tenancy as long as you followed the necessary steps to do so. And that means if I have severed my joint tenancy, for example, to my son, when the person who surveyed their joint tenancy dies, it is highly impossible that the remaining joint tenant will get all of the land. So how I would have learned is, I'm trying to make it as simple as possible. If, for example, A, B, and C all got property from their parents, C died and he did not sever his joint tenancy. B died, but he surveyed his joint tenancy. A, the remaining tenant, will get all of C's share, which means A will now have 2/3 of the property, but he will not get B's share because B had surveyed his joint tenancy. So now he will only have 2/3, and then whoever B surveyed his joint tenancy to can come and claim interest for what has been surveyed. But this is only if the land has been surveyed. So if it's a case where him never surveyed the land, his kids cannot come and claim and say, oh, but my father had a share, my father had no, because he did not survey his joint tenancy, which means all of what he had will go back to the other joint tenant because they had it in joint tenancy for both of them. So if one died, the other person will get all of the land. But if you surveyed your joint tenancy, then those who you surveyed to can make a claim. The reason for this is because Well, we know that there are two areas of law, especially in property and in equity. In property and in all English real property law, is that you have equity and you have the common law. One of the things was that the common law was so harsh that the common law would make it a case where, well, if A, B, and C have land and you have kids and you survey to them, or you don't, the other person would still get all of the land. So that's the common law. It's really harsh. But equity comes in a way that sees the benefit of all persons. So equity ensures that, okay, if you have a child and you decide that you want to give your child something, your brother cannot kick your child out, because that would be unfair. So it would really be unfair for two brothers to have a land, and the brother surveys to his, or says to, or writes in his will or whatever, that, or in his lifetime, sorry, that he's going to give his son a share. And when he dies, the other joint tenant comes and says, well, it's my land because we got it in joint tenancy. No, that would be unfair because you surveyed it. So in equity gave a chance for persons who would have, or better yet, a tenant. So there's A and B, and B rents his premises, or leases, let's use leases just to be careful, leases his premises to C. And because B dies, A can automatically come. After B have been collecting money from this person, and they have a contract, they have a legal contract saying, I lease this premises to you. A, because B is dead now, A could come and say, well, we're joint tenants, and I don't care if you have a legal document with my brother is dead, and so I am going to take back my premises. That would be really unfair. So equity came as a way to quell the harshness of the common law, so that if the person had leased their property or whatever, A could not claim all of the land. You have your 50%, but the person who he leased to will have a legal interest in the land as well. So that's how survivorship, that's the perfect explanation of just a crescendi, or the right to survivorship. So if they die without surveying the land in their lifetime, the other joint tenant will get all of it. But if they did, then you cannot claim all of the land as a surviving joint tenant. Are there any questions before I move on? Because I know I did say a handful, and as I said, real property is not really the best or easiest thing to explain. So are there any other questions that I can see how best I can answer them for you? All right, no questions, then we'll move on. So we're going to get into the meat of the matter now as to the 4 unities, which is what the question really asks about. So as I said, if you leave off one of them, or if you leave off 2, please count that you have just lost a bulk of marks. So the 4 unities are unity of possession, unity of title, unity of interest, and unity of time. And for there to be a joint tenancy, or for there to be anything to do with surveying or right of survivorship, these 4 things must be present. If you don't have these 4 things, then you do not have a joint tenancy. You cannot survey the land saying that you based on joint tenancy, and you cannot claim the land if the other person dies based on the right to survivorship. So for there to be a joint tenancy, or for a joint tenancy to exist, All right, so is there anyone that can tell me what is the unity of possession? All right, so before I go any further, when we talk about unity, we talk about you doing things together, right? So when we talk about unity, we talk about everybody having jointly this thing, right? So if there's a, if we have unity of a pen, I'm holding a pen. If we have unity of a pen, it means that both of us hold the pen together. So when I talk about unity of possession, what am I talking about? What is unity of possession? To the entire land. Okay, all right. Thank you, Kenny. So that is true. So on the unity of possession, legal claim to physical possession of the land. It means that A cannot claim that he owns the entire, especially because the other person don't die yet or don't serve it. You cannot say you own the entire land. You by yourself. So you cannot bring your brother to court claiming that he removes his house off your land because it's your land. No, your parents gave you in joint tenancy, or anybody who gave you the land gave you in joint tenancy and gave you and said you should hold it in joint tenancy, which means you both have unity of possession of the entire land. So if I want to build, if my brother and I both have unity of possession and we're joint tenants, we have unity of possession. Therefore, I can build anywhere on the land I want to, and he can build anywhere on the land he wants to. None of us can stop the other. So I am going to all right, so remember that the question is saying that you should explain the 4 unities. So if you do not, if you just drop them there, then you're not going to get any marks. So you have to explain it perfectly. So I will give it to you and you can, I don't know, I don't want to tell you to SWAT, but you can use this as a guide. Hello? Hello? Okay, guess that was a mistake. All right, so I would have had added some additional information on what I would have discussed here, but it's really for you to understand. So it's really for you to understand that the court is not going to be, as I said, they're working with equity. So with equity, you have to be fair. So while you have unity of possession and while you can go anywhere on the land, as I said, no one can come and claim one part of the land. It's expected that we are going to be fair as joint tenants. So if A and B both own the land, it's expected that A won't, well, as I said, it's unity of possession. So it's expected that A won't try to say, okay, I got the house and the house have three rooms, so I am going to take all 3 rooms for myself. Or B will say, I'm going to take all 3 rooms for myself. Unity of possession means that we will work together as one because we both have possession of the entire land. So I won't try to oust my brother or oust my sister, and we will be fair. So we will probably split the land and say, okay, I will take from that gate to this gate, and you can take from that gate to the other gate, and then we can both build on the land. So that's unity of possession, meaning that we both own the entire land and we can go anywhere on the land, but we will be fair and we will try to split the land equally between us. So we will now move to unity of title, and just give me a minute. All right, so anyone can explain on unity of title? Nobody at all? All right, so under unity of title, each tenant must have the same interest in the land and must obtain it from the same. Nobody's going to answer. All right, so under unity of title, so for time's sake, I'm just going to go. Okay, someone responded. Okay, so yes, that is true. Under unity of title, the persons must obtain the land from the same document. So if it cannot be that you obtained it from your father's will and you claim that you obtained it because your mother just served it to you. It cannot work like that. So under joint tenancy, and for anything under joint tenancy to apply, the persons must obtain it from the same document. So you must, if A gets it from his father's will, B must also get it from his father's will. All right, so as I said, for time, I'm just going to finish this and I'm going to send it to you guys because I don't want to hold up your time and I do want to go to co-ownership after. So I'm just going to, because basically it's really just explaining the 4 unities from this point, and I think you guys would have understand how to write an essay from by now, is that you start with the definition of the overall title, and then you go into explaining things that can happen under joint tenancy and how do people come about joint tenancy, and eventually you will have to explain what the question is asking about, which is the 4 unities, because that's what the question is asking about. But I really just wanted you guys to see how you write the essay, and because time is going and people are actually leaving, because I think this is kind of getting a little, so I am going to move on to tenancy in common and to actually answering the other parts of the question so that you guys can stay involved. But I will send the essay to you later. So I will send it in the group if that's okay. If you have any questions about joint tenancy, you can forward them to me now before I go into tenancy in common. Any questions before I move on? I know I'm not finished on the side, but I will finish and send the information to you later. All right, so I am going to go into tenancy in common now, which is the second part of the question. Just give me a second. There is a question? Okay.
No, man, I was just saying no, I don't have any. Yeah.
Okay. All right, so given that you would have, I want you guys to understand that when you get questions like these, they're split in parts. You might have one question that says it's 30 marks, the other might say 12, or one may have way more than the other, vice versa. It may work that way. But so one of the things, and then you don't have a lot of time. So one of the things that I want you guys to understand is that you don't need to repeat everything that you would have already repeated in section B if both section A and section B coincide with each other. So for example, we already just spoke about joint tenancy. From start to finish, we went into the unities, we use cases, we explained everything. You don't need to come back down here and write again, joint tenancy is, or whatever that is. I don't expect you to do that because you don't have enough space and time to do that. And you don't get marks for repetition. If anything, the examiners will get annoyed and they will just move on with their lives. So what I want you guys to do now is to focus more on tenancy in common and what is a tenancy in common. Do you guys want me to continue writing out the essay, or do you want me to just read it to you and then send you the essay later?
Miss, I can write the essay.
You want me to write the essay? Okay, all right. All right, so remember the main part of this question, I want you guys to remember the question here. So the main part of the question is that you must tell your clients, or you must explain to your clients, sorry, the differences between joint tenancy and tenancy in common. So in all that you're doing now, do not just go into the exam and write, okay, a tenancy in common is, give me a second, guys. Give me a second, please. All right, I'm back. So I don't want you guys to just go to the exam and drop. Joint tenancy is, and the 4 unit, or well, just go into the exam and drop. The 4 units, you're answering the question and you decide. The 4 unities are, and then you go, a joint tenancy is, a tenancy in common is, and you leave it like that. And you might laugh, but people do that. And that is why you might have a difference with a person who gets a distinction, meaning a 1 or 2, and a person who are even a 3, and a person who might get a 4 or 5. I don't know if 6 is a passing grade. But you might have those differences because there are persons who go into the exam and they write their lives out and they actually make sense, as in they don't do the kitchen sink, which I spoke about this morning, where you just go in and you just throw everything in one, what you know, and leave it like that. But there are persons who actually apply themselves. And yes, you can apply yourselves in an essay. And I want to give you a little secret. They do mark essays harder than they do mark problem questions, because they know that with essay, it's easier for us to just write and rant and talk and not actually answer the question. Given that it is so plain that they say what you should do is to distinguish them, please don't spend the entire time writing about a tenancy in common. Please ensure that you distinguish what is the difference between what are, if there are any common features, and what is the main difference between a tenancy in common and a joint tenancy. So, anyone knows what is a tenancy in common? Because I would have explained that a little before. So I'm hoping someone can explain to me now what is a tenancy in common. Remember, I said to you that joint tenancy is shared 50-50 because there are no words of, there's no words of there's something specific. There's a specific term that I use. And basically you just need to turn that around and give me the definition of a tenancy in common now. So if a joint tenancy is without words of severance, then explain a tenancy in common. You can use the chat. Thank you, Cornelia. So Cornelia said that a tenancy in common is where each tenant has a distinct fixed share in the property and there is no just a crescendi. So that is true. So in a tenancy in common, it's somewhat easier. For example, if you die and your land is supposed to share or whatever, you don't have to survey during your lifetime. If I have a tenancy in common, because the shares are separate and we don't hold a unity, we don't hold some of the unities, sorry. My family, sorry, my kids can come and claim my parts of my share, sorry, without actually having to contend with someone else who can say, oh, well, he didn't survey his land and we're joint tenants, so I can get everything. That cannot happen with tenancy in common, because tenancy in common actually uses words of servants. So that is the main difference. Tenancy in common uses words in servants, where if I own Black Acre and I do a tenancy in common, I say, for example, when I pass, I want my land to go to my kids, A and B, with A having 2/3 of the property and B having 1/3. That means I did not give them in joint tenancy. If I give you in joint tenancy, it means that I say I give my property, Black Acre, to my kids, A and B, and leave it there, or A and B in joint tenancy. So words of severance, deals with those shares where we would say 2/3 and 1/3, as explained before. So the main difference with a tenancy in common and a joint tenancy, again, is that one uses words of severance and the other does not. And because one uses words of severance, some of the unities that I think there are only 2 unities that actually apply to both joint tenancy and tenancy in common. And it means that if one party dies, the other party cannot automatically claim all of the land. So I'm going to go ahead and write. Give me a minute. So after I would have explained that no, we need to show the difference. So we need for them to see the clear difference. So I'm going to go into talking about the difference now between a joint tenancy and a tenancy in common, because that is what the question is about. So as I said before, if you don't talk about the difference, then you would not have answered the question. So please, 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 I beg you guys, do not do the kitchen sink. They hate it, they hate it, they hate it. Even though they're scripted writers, they will mark you down severely. All right, so I remember earlier I said that there may be a case where I think it was just two of them that two of the unities that you must have. I stand corrected, it is actually one, and it is the unity of possession, which means that you don't have to get you don't have to get your part of the land from the same document, and you don't need to have unity of interest, nor do you need to have unity of time. The only thing you guys need to do is to know that you both own the land. And this is because, as I said, you can survey your land anyhow you want, and it can even be surveyed in debt. So it's really difficult for persons to have the unity of title, because your grandfather might have given his land and share it up to you, and then my grandmother might have given it to me. And so with tenancy in common, because you hold separate and fixed shares, it's sort of hard for persons to have a unity of title. I'm going to write a case here which defines it. And it's essential because you can't really explain the differences without actually using the law.
Miss, in the essay that you're writing, Miss, will you be giving like the cases to go along with it as well?
Yes, I'll give the cases, and I will also give essential cases that I won't have here.
Okay, that is good.
All right. Okay, so I would have used a case here because well, we've always learned that in writing essays and in explaining anything that you are asked to distinguish, you must always look at a comparison. And so the first thing that I would have talked about is the fact that a tenancy in common speaks to two persons having a separate and fixed share, which shows you the actual definition of the term. But then we have to look at the fact that even though it can be distinguished from joint tenancy, they do have one thing that is alike, and you must know that because you want to show your examiners that you understand. You understand, yes. So there is unity of possession, and that was explained perfectly in the case Bull and Bull, where the son and his mother had purchased the property together, and the son tried to evict his mother, but he could not do so. I'm guessing he thought, oh, I could evict her because this is not a joint tenancy, so we don't have the land, like it's not 50-50, so if I pay more, I can evict her. No, they do have a unity of possession, so that is a similarity between the two. There's a unity of possession, so if you have a tenancy in common, you cannot evict the other person just because you paid more, because they have a legal interest. And again, this falls under equity. But the thing is, there is words of surveillance. So I cannot bring you to court now and say, oh, well, and just make a random claim that I own 50% of your land if I only own 1/3. So that's where the difference is with tenancy in common. I can't take you to court and claim 50% because if I only own 1/3. And if you die, I cannot come to court and claim your 2/3. No, your heirs will get your 2/3 because there is no right to survivorship. The next part that so those are the similarities and the main differences. The other parts of the question that I want you guys to focus on is to actually, go ahead.
No, continue.
Okay, all right, so the next part of the question that I want you guys to focus on is that even though it is an essay question, because you are advising your clients on the differences between tenancy in common and joint tenancy, you must now advise them as to why you would tell them to actually do joint tenancy or tenancy in common when it comes on to sharing to their 10 children. You must also take into consideration all the facts, one of which is that it's a blended family. So they have 10 kids and only 8 they have together. But if you buy a property together, you would not want it to be a case where your 2 kids claim that, okay, we have joint tenancy because we are not born out of wedlock and we were born together, and so this is our parents' homes and you guys were born, differently, and all of that mixed up. So you want to advise them why a tenancy in common would be better than a joint tenancy. I don't know if anyone wants to take a shot at that before I continue. Nobody? All right, so one of the reasons why it's better for them to do a tenancy in common is that, as we have seen before, each of their children, they have 10 children, and they were born, they weren't all born into wedlock or to the same parents, which means really and truly, if my brother and I, we're not half brothers or we're not half brother and sister, and we have both parents, and we can say, okay, we can work together in harmony because, we love each other that much, and we can work together peacefully, and our children will grow up together and we'll love that, so we can share our land and we don't have a problem, fine. But if you have 10 children, half of them is your stepchildren. They don't really share that much relation. Some of them don't share any relation at all. They probably don't like each other. You might create a problem for them. because there will be a right of survivorship. And their intentions, whatever their own intentions are, you would have been quelling that. And so it's best for you to have a tenancy in common where each person can have their own share and they can dispose it as they like without having to contend with each other. Whether or not they like each other, whether or not they're blood related, they won't have that difficulty. So I will go ahead and write it here. Yeah, so again, as I said, because they're not, most of them, they are not really related, because a lot of them are would have been stepbrothers and stepsisters. So while they're related because of the blended family situation, we know that in truth and in fact they're not blood related. They may not be able to work together, and if they have their own kids, they may not care for their stepbrother to have any relationship with their kids or anything like that, and may intend for their share of the property to go to their kids and all of that. But we have to remember that if it's a joint tenancy, they all have to share the property together. And if they die before surveying the land, then all of their land would have gone to their stepbrother or stepsister and would not have gone to their own children that they would have had, and their children can't make any claims. And because it's such a large family, and because it's so problematic that they weren't all born to the same parents, it would be difficult and it may not be equitable. So that's why it's best for the parents, for the sanity of their own children and for it to be equitable when they die and when the children die, it's best for them to do a tenancy in common instead of a joint tenancy. So you see how this other paragraph, it's advising the parents, but while it's advising them, it's still also showing the main difference between a joint tenancy and a tenancy in common, which is the fact that each person gets their share. And if one dies, it doesn't automatically pass to the other. It passes to who you would have intended for it to go to. And I'm sure if someone has one child and they die, more than likely they're going to want their property to go to their one child instead of their brother or their stepbrother or stepsister. All right, so this is just some additional details that may be useful for you. I really don't think it would be much of a plus, but I think you can use it. So it was explaining as I Well, I had explained it before I wrote it. So the fact that, because they're not biologically related, all of them, there may be a lot of feuds and there may be a lot of problems, and someone might try to get rid of somebody, but they you also have to make mention of the fact that because there is still unity of possession, they cannot evict each other. So despite the feuds, they can't do anything to each other. But it's still best to have a tenancy in common, just for the sake of making it clear who gets what share, so that you can avoid the feuds and tensions. As I said, I don't think it's really necessary to write it, but it might help. All right, so I'm going to write one more paragraph, and then we will take a break, and I will come back and do the co-ownership for you. Hopefully the co-ownership questions that I see are problem questions, because I think problem questions are more engaging, but we cannot ignore the fact that you might get an essay. So it's good that you know how to write an essay. We don't like essays. Nobody really likes essays. God bless you if you like essays. But I'm going to write one more paragraph, and then we'll take a break and we will come back. But it won't really be a long break. I'm guessing 15 minutes maximum. Give me a second. All right, so I'm going to save this. Well, I need to finish the joint tenancy section. So I'm going to save it and I'm going to send it to you and you guys can review and you can use it as a guide for when you're studying. Give me 1 second. So the main differences that we have, just to review them or just to give you a basic rundown so that when you're reading over the essay, you can actually understand it, is the fact that with a tenancy in common, there are words of surveillance and there is none with the joint tenancy. And with the joint tenancy, there is just a crescendi, the right to survivorship, but with tenancy in common, there is no such thing. And as it relates to these persons with their 10 kids who are not all biological to each, there are stepkids and there's a big, large blended family. It's best for them to use a tenancy in common because it will avoid all the feud and the problem and the fuss for persons who may not really be connected to each other. Also, it's unfair for you to have sharing a land and it just goes to who the law determines it should go to. So one brother might end up getting all of the land at the end of it. So if the 9 other siblings died before him, he will get all of the land, despite the fact that all these other siblings would have had their own children because of the right to survivorship. So it's best for them to ensure that they use tenants in common because of the words of severance and the fact that each person gets their own share. And when they die or anything, the court or the law can easily say, okay, all right, tenant C's share will go, tenant C's 1/10 of the land will go to his children. So that's the main difference, and that's why it's best for them to use it. I will save it. I will finish the other part about the unity of possession, no, unity of time, sorry, unity of interest, and I will send that to you. So we're going to take a break now. I'm going to ask that we take a 15-minute break. I don't think the session is going to go up to the full time that we have, so because I really don't want to keep you guys all day. But we're going to take a 15-minute break and then we will return and we will finish co-ownership. All right, guys, I am back. I hope you had a good break. Sorry, it was a little more lengthy than it should have been, but I was trying to get everything together for co-ownership. I really won't be sharing my screen a lot here, apart from for the question, and that is because some of the information that I'll be using here are not just the information that I get from your study guides or from your textbook. Some of them are things that I would have been using in school, in my own university area here that I believe are valuable to you. And sharing some of that information might not be for the YouTube, where it will be on YouTube, might not be so safe for me. So I'll have to be careful how I disseminate that information. But I really want to help you guys, and I do believe co-ownership is an area I'm passionate about, but I know it can be a difficult area. And I really want to help you guys, so I have to be careful with how I share the information. I do hope that you guys can understand that. I will share the question because I understand that the question, I don't want you guys to not follow, but I have to be careful with how I share my information. So one of the past paper questions that I found for you, it gives two parts. There's a essay part and there's a problem question part. I'll go through the essay part, but not like how we went through the essay a while ago. I'll go through the essay part, giving you pointers which are essential to this area. So I want you guys to remember them. You can use your pen and paper and write them down. You are told to bring your pen and paper. You can use your pen and paper or your pen and books to write them down. And then I will eventually go into the problem question where I will share the question. So is that okay with everybody? Everyone is fine with that? With me not sharing some of the things on my screen?
Yes, it is okay.
Okay, all right. So the first part of the question that I see is for you to, I think it's, give me a second, let me just look back at it. I think it's for you to tell the difference between a lease and a license. Let me just confirm. Yes, so to distinguish between a lease and a license. All right. All right, so the first thing I want you guys to note is that co-ownership speaks to, it's different from land ownership. And it's different from joint tenancy. Land ownership, sorry, which includes joint tenancy and tenancy in common. It's not like someone dies and or someone surveys and gives their land to two people or three people. It's not a case like this. Under co-ownership, it speaks to two persons basically having an interest in the land at the same time, yes, but it's not a case of joint tenancy. Here, it speaks to where it's normally refers to a landlord who is leasing his property to a tenant, meaning he's still alive, he still has full interest in the land, but he has, I don't think you want to say loan, but the person is paying for it. So the person pays, he gives his property to someone for them to use it for a specific time while they pay him normally rent. They normally pay him rent for a number of years. So here I have leases allow two or more people to enjoy the benefits of owning an estate in land. The freeholder, which is the landlord or the person who owns the land, is said to hold the reversion.
Can you repeat, please?
Okay, sure. All right, so leases allow two or more people to enjoy the benefits of owning an estate in land. The freeholder or the landlord is said to hold the reversion expectant on the lease. Or you can just say they hold the reversion. It doesn't really matter which one you put. And the lease is held by the tenant. The landlord receives rents or profits while the tenant enjoys possession and occupation of the property. Everybody got that?
Miss, can you repeat from the tenant?
All right. So well, I said two things about tenants. So let me just. All right. So the.
So the lease is held by the tenant.
Yes. So the landlord receives rents or profits while a tenant enjoys physical possession or occupation of the property. Also, remember this will be on YouTube. So if you guys miss something, and because we're kind of on time, so if you guys miss something, then you can always go back to YouTube and look for it, if that's okay. Can I continue? All leases will contain covenants or promises on both the part of the landlord and the tenant. Some of which are express covenants, which are agreed between the two parties. But there are also implied covenants, which are normally implied as a matter of law by statute or common law. And all covenants are enforceable as between the original landlord and the original tenant in certain circumstances. All right, so how do you distinguish between a lease and a license? Is that you must look at the characteristics of both. I want to explain to you. So I want you to draw in your book, sorry, a line, and you're going to put license, or you can just put at the top leases and license. So I'm going to give you the characteristics of a lease first, and then I'll give you the characteristics of a license, and then we can see where the difference is between both of them. All right, so the leading case on this matter, I want you to make a note of that, is Street v. Mountford. So it's STREET VM, well, V as in to represent Anne. So it's, yeah, just put V as to represent Anne. So Street and Mountford. So Mountford is spelled, sorry, MOUNTFORD. I'll just tell you what happened in the case, and then we will continue from there. So in this case, the landlord granted the appellant the right to occupy a furnished room under a written agreement, which stated that the appellant had the right to occupy the room at a license fee of €37 per week. And this personal license is not assignable, that the license may be terminated by 14 days with written notice, and that the appellant understood and accepted that a license in the above form does not and is not intended to give a tenancy protected under the Rent Act. The appellant had exclusive possession of the room. Some months after signing the agreement, the appellant applied to have a fair rent registered in respect of the room. The landlord then applied to the county court for a declaration that the appellant occupied the room under a license and not a tenancy. The county judge held that the appellant was a tenant entitled to the protection of the Rent Act, but on the landlord's appeal, the Court of Appeal held that the occupier was a mere licensee, since, notwithstanding the fact that exclusive possession, the agreement bore all the marks of a license, and the parties had in fact only intended to create a license. The appellant appealed to the House of Lords. The holding was such that the test whether an occupancy of residential accommodation was a tenancy or a license, and this is where I want you guys to start writing. So the test whether an occupancy of residential accommodation was a tenancy or a license was whether, on the true construction of the agreement, the occupier had granted exclusive possession of the accommodation for a fixed or periodic term at a stated rent, and unless special circumstances existed, which negative the presumption of tenancy. In other words, what this case was saying is that a tenancy, or a lease rather, arose whenever there was a grant of exclusive possession for a fixed and periodic term at a stated rate. And this is the main difference between a lease and a license. I will go into further details, of course, but this is the main difference between the two, which is why this case is important and why I said it is the leading case. And so if you have not read this case, I encourage you to go and read it, Street v. Mountford, because these are literally the words that it gives you. A tenancy arose where there is a grant of exclusive possession for a fixed or periodic term at a stated rate. And this was explained by Lord Templeman. So in all honesty, that's the basics of the case. So you could just write back this, but I want you guys to really read the case and understand it, because if you don't read it, me telling you this, you may just drop the principle on the paper, but you don't understand it, and that would not be good for you. You can also look at the case Bruton and London and Quadrant Housing Trust. So that's Bruton, B-R-U-T-O-N, V London, L-O-N-D-O-N, and Quadrant Housing Trust. It will also explain to you the difference between where a lease is created. But the important thing that I want you to get from this is that Lord Hoffman, that's L-O-R-D, Hoffman, H-O-F-F-M-A-N, states a lease or tenancy is a contractually binding agreement not referable to any other relationship between the parties, by which one person gives another the right to exclusive occupation of land for a fixed or renewable period or periods of time, usually in return for a periodic payment in money. So it's basically saying the same thing as Lord Templeman in Street and Mountford, probably just wording it differently. And so the main characteristics of a lease is that it is exclusive possession given to the tenant for a certain period of time for money. So the three main characteristics of a lease then are exclusive possession, certain duration, and rent. Now, what is exclusive possession? Exclusive possession is the right of the tenant to exclude everyone from the premises, and this includes the landlord. So the tenant therefore has the right, the proprietary right, and is capable of maintaining an action of trespass against those who enter the demised premises without permission. Now, this is where we get into the difference between a license and a lease. Under a license, you do not have exclusive possession. So I have to make that clear. You do not have exclusive possession under a license because it's someone basically giving you permission to enter their property for one reason or another, whether to just stay there or to carry out some work there. And so it cannot be that you are able to use the property, that you are able to have exclusion from, to exclude everyone from the property. So if I give you my property just to come and to carry out some work, you cannot state that, oh, me as a landlord, I cannot come on my own property. So you need to see that the main difference between a license and a lease is that with a lease, you have exclusive possession as long as you're paying my rent and it's for a certain period. But you cannot exclude, if there's a license, you cannot exclude me from my property because it is only permission to use my property. Give me 1 second, please. All right, so the laptop is giving me some problem. So just give me a second. All right, so one of the leading cases that you will have to use under co-ownership, and you will see where you will have to use it, especially in the problem question that I'm going to give you or that I'm going to go over, is because it speaks to the main difference between a license, or it was very unclear in this case as to whether there was a license or a lease. So this case is Errington and Woods. And Lord Denning in this case has posited that what was essential was intention leading to a subjective assessment, considering whether a wide range of facts to determine whether a relationship was personal in nature. See, one of the things in this case was that you had a father-in-law. Well, a man and a woman got married, and they were living together. The father-in-law had given them the premises, I'm guessing just as a wedding gift. But the father-in-law died, and well, he said they could make the payment for a certain amount of time. As long as they made payments, when they were finished making the payments, they were able to claim the property. The father-in-law died, and then shortly after, the son and his wife broke up. But what had happened was during the time that the father-in-law was alive and that they were married, they were paying the mortgage, as he said. He said they could pay the mortgage, and then when they were finished paying the mortgage, they could get the property. So that's how it went. Sorry. What had happened now is that he died. The wife, she was still continuing to pay her mortgage. Even when they broke up, even when she divorced her husband, or when they divorced, she was still making payments on her mortgage. However, at the end, after a while, the mother-in-law, that's the son's mother, the father-in-law who owned the property, who died, his wife, came and made a claim that she wanted the premises. But what happened in the court was that the question was whether it was a license or a lease. But it was a license where, oh, I just gave you a wedding gift. Because one of the things that is essential for you to know between a license and a lease is that a license is normally a gift. Like, oh, you can use my premises for this time. I'm just giving you for your birthday, for a weekend, or for, you can use my, but I'm not really leasing it to you. You can't, there's no agreement. You can't establish any covenant, nothing, because it's not exclusive possession at rent for a certain period of time. So here, one of the contentions in this case was that it was a license. It was a wedding gift. You can use my premises. You're not paying me rent or anything. You're just paying the mortgage. But the court said no. The fact that they were paying the mortgage showed that it was not just a mere license, but it was a lease, right? Because they were using, you were allowed to use the premises you were allowed to use the premises subject to the fact that you're paying the mortgage, and after you pay the mortgage, you would get the premises for yourself. So that was a lease and not a license. 1 second. So yeah, so I can read the facts to you here so that you can get it a little better than what I was memorizing from my head. So in an action by a widow against her daughter-in-law for the possession of a house, the Court of Appeal ruled for the daughter-in-law, declaring that 1, the occupation of the house by the son and the daughter-in-law was not determinable by the widow on demand, since they were entitled to remain in possession so long as they paid their mortgage repayment installments, and therefore they were not tenants at will of the promise. The daughter-in-law and her husband were not weekly tenants or tenants for the period during which the installments failed to be paid. And lastly, the daughter-in-law and her husband were licensees having a permissive occupation short of a tenancy, but with a contractual or equitable right to remain in possession so long as they paid installments which grew into a good equitable title to the house and when all the installments were paid. So they didn't really use the term that it was a lease or anything. So really and truly, they were still licensees, but the house could not be taken from them given the fact that it was not just a mere gift. They were paying, and because they were paying the mortgage, they would receive it at the end of making payments on the mortgage. Therefore, they had an equitable right and they could make a claim for the premises, which is not usually the case with a license. A license, you usually don't have exclusive possession. So, as I said before, the first thing that you must identify is that where there is a lease or co-ownership rather, you have exclusive possession for a certain time as long as you pay rent. But where it's a license, you don't have that luxury. A license is where you are just given the opportunity to enter the premises for some time to do some form of business or as a gift just for some time. Just as a gift, someone giving you the ability to use my pool house or my guest house, but you don't have any equitable interest in it. On the other hand, you do have equitable interest where there is a lease. Any questions so far? Any questions? All right, so how do you actually identify them? Because something, if I'm paying rent, for example, I'm paying rent and I may have exclusive possession, but I may not have a license. I may not have a lease, sorry, I may have a license. Why? Because there's no duration. And there are special circumstances where the duration, may be uncertain. And the courts have ruled over, well, in some cases, that where there's no duration, then you cannot have a lease because you don't have all 3 things that must be present. One of these cases is in cases of war, because you don't know when war is going to end. So how can I put in a lease that it is for a certain time that I'm giving the lease if I cannot tell when the war is going to end? And so you have had cases where the court would have said, hey, this is not a lease because you don't have any, you can't confirm when the time is going to end. What I will do is to try and put this into one document, and I will send it to you guys in the group so that you don't be as confused as you probably are now because I'm just talking. So I will try to convert it into one document and I will send it to you, the difference between a lease and a license. Give me 1 second. So I will just read something to you that will probably simplify everything, and that should help you with this. Give me a second. Can you just put on some music for about 2 minutes while I find this document, please? All right, so to just give you a summary and to make it much better for you, one, you must identify, when you have a question like this to distinguish between both a lease and a license, you must identify the difference between the two, which is the fact, you must be able to identify when there's a lease and when there is a license. So identifying a lease, you must know that you must see where there is exclusive possession, and it is for a term of rent, and it is for a certain period. I'd advise you already that you can use Street v. Montfort as your principal, especially where Lord Templeman's speech, because that will carry you right through. You must find out if exclusive possession is really decisive, or if it can really confirm that there's a lease. Because there are cases where there is exclusive possession, but the person did not have a tenancy. And this was the case in Earlington and Earlington, where they did have exclusive possession, but they did not have a tenancy. So you must note this. So you must note, first of all, that exclusive possession determines a lease. But because it's an essay, you're going to go in depth to say, well, if you do not have exclusive possession, it does not determine fully that you do not have, you must explain that there are cases where you can have exclusive possession and it really does not say you have a lease, because in Earlington, they did have exclusive possession, but it's not a case where they had a lease. So they could exclude the mother-in-law from coming onto their property, but it was not a lease because there was no tenancy. You must be able to identify a license. In identifying a license, you must look at whether it is a personal privilege given to the person, or whether it's a case where they have an interest in land. So that's another major difference that you must look at. Is it a gift? Is it just some random act of kindness, or do you actually have an interest in land? Again, Street v. Montfort helps you here. And it is assumed that you have a license if the special circumstances which are described by Lord Templeman exist. And the special circumstances which he explained are the fact that there was no intention to create legal relations. And this is usually seen where there is some family relationship. Like as a father, you are my daughter and I'm just allowing you to live at my house, but there's no intention for me and you to create legal relations where you can occupy my premises for a period, for a certain period at some money, for some money. It also includes service occupier. What that means is, for example, you are working on my premises as a servant, you are building something on my premises and I allow you to lodge there. But I do not have any intention to create any legal relations with you apart from probably employer and employee or master and servant. So you can't claim or exclude me from my premises because you are only here as a servant. Street v. Montfort again will help you.
Could you please type that in the chat, please? I was asking, but I guess I didn't see the message.
Oh, the name of the
case
case?
name. Yeah.
Okay. Give me a second.
Okay.
One second. There you go.
Thank you.
Yes. And there are a few other cases that I'll also type in the chat where you can look at where no tenancy was created. It was only a license. Give me a second. Let me just post all of them here. All right, so in the last case that I sent, the case, it's Ramnarans and Lutchman. It is important for you to look at this case. The reason being is that there was a, the court, this is where the court really looked at whether there was an intention to create legal relations. And this is how they determined whether there was a lease or a license here. Because just as how I explained before, that you can have a case where the person had exclusive possession, but they don't actually have a tenancy. It's the same way you can identify, you can see where there's a family relationship, but there's a lease and not a license. Reason being is the fact that if I am your uncle and I charge you to live in my premises and it has all the characteristics of a lease, I cannot contend, or we cannot go to court and say, oh, well, you default on your payments or whatever. You cannot go to court and say, oh, well, my uncle was just generous and he just, I was just staying in his premises, so I don't have to pay any money. No. If it has all the characteristics of the lease, then it is a lease, regardless of whether it's your family member. So in this case, the plaintiff had exclusive possession. However, the court mainly looked at the fact that her occupation was not only owed to her uncle's generosity, but there was an agreement for her to purchase the land in due course. It was clear that a lease was created because there was exclusive possession and payment of rent for a specific period or certain duration. And there was an intention to create legal relations. So because there was an intention to create legal relations, it ended up that it was a lease and not exclusive, and not a license. Sorry. Another thing we have to look at is sham agreements. And where there is sham agreements, it's because of all the issues where the landlord, they couldn't tell the difference between a lease and a license, and you needed to just put in writing, basically put in writing, or well, because exclusive possession, let me correct, was not considered decisive. You remember I said it earlier, exclusive possession is no longer decisive, because you can have exclusive possession and still have a license because there was no tenancy. The court used to take an approach where they would look for specific terms in an agreement that would determine whether there was a tenancy or whether there was a license. So a lot of landlords would start something where they would just put it in the agreement that, you know, they intend, this is a license, and the court was supposed to accept that. So a lot of landlords, you know, unfair, mischievous landlords would get away without being bound to the rules of the Rent Act. So the court now had to take a different approach than just looking at the terms, and had to look to find if the agreements were creating a lease or whether they were actually creating or whether it was just a license. Give me 1 second. And so what the court would look at in this case is, again, the first 3 things that I said to you guys, which is why I keep repeating them. So if you don't have those first 3 things, just know that the question is, you're not going, yeah. So they would look at exclusive possession, but they would mainly look at whether it was for a fixed period of time and whether there was rent. So not because landlords will put in there that it's a license. So maybe you get a problem question, who knows? I don't know. Maybe you get a problem question like this, and there's something where the landlord puts in there that, oh, there's a license. Do not answer the question and say, yes, it's a license, because the landlord puts in there that it's a license. No, CXE may just be testing your knowledge, and they may just put it there because they know that there's something called sham agreements, and they want you to be able to say, well, no, a lease is exclusive possession for a periodic time, for a certain period of time, and it is at you're paying rent. So I don't want you to just be open to the fact that because I see license there, I must put that it's a license, because it may not be an essay question, it may be a problem question. So I want you to get that and to ensure that you are careful with what you're doing. So the court cannot say it's a license simply because licensing is in the provision. They must see that it fulfills all the things that have to do with a lease. All right, so remember I was saying to you earlier that when we speak of certainty, we usually speak of a certain time. But one of the problems is that it's not just duration, because even with, if you ever hear of people just renting a house, most time they don't say, oh, we're just renting your house for 2 years or for 3 years. Sometimes it's there, sometimes it's not. Sometimes it's for 99 years, sometimes it's not. And one of the problems that I had explained to you originally was that there was the issue with war, because there was this case called Lace and Chandler. Let me put that in the chat as well. Oh, somebody's hand is up. Go ahead. J. Your hand is up. You were saying something? Okay.
Oh, I was saying that my apologies. It was up from when I wanted to ask about the cases. I forgot to
Oh,
lower it. My apologies.
okay, all right, no problem. So in this case, duration of war, it was held that duration of war does not create a good leasehold interest as it is uncertain as to when the lease will start and when it will end. However, this case was distinguished by another case named Ashburn and Arnold and another. Let me put that in the chat as well. Ashburn v. Arnold and another, where it was held that where the agreement states for a term to be determined by the landlord, the period is not uncertain. So I want you to know that, all right, so there are cases where we say, okay, we don't know when war is going to end. We don't know if the hurricane is going to end in 2 days or 3 days, or if it's going to linger for a month. So we cannot say, oh, we're just renting for that. So persons will say, oh, because the duration is not certain. But Ashburn is saying you have to look at the facts. So if the fact says that the landlord, if the landlord says, I am renting you the premises for a term to be determined by me, and I will tell you the term at a later date, then there is still a lease. So you have to look carefully at the facts. So that's what I want you guys to know. Certainty of duration, sometimes it will say 2 years, sometimes it will say 99 years, but sometimes the landlord will just put in it and say, I will determine at a later date how long the lease is for. And we see that a lot in even our Caribbean cases. Or if you are living on a street where somebody is renting to somebody, you may find that that's the case, that they don't actually put a term there. So will you say that's not a lease? No, if the landlord says, I will determine the time, then there is a lease. So a tenancy will not be created unless there's a period when the lease starts and it ends. But the period must be certain. However, certainty does not depend on specific time period. So that's what I wanted to get. There must be a certain duration, but it doesn't mean it has to be 2 years, 3 years, 4 years. The certain duration can be based on the landlord just saying, it's whenever I say it is. And then rent is usually dependent on, like, for example, money. Because Lord Templeman in Street says that, where there is no, for us, it's usually dependent on money. And where there is no rent, there is normally assumed that there's no lease. And that was explained by Lord Templeman in Street. However, one of the cases that overturn it, which is why I placed it there, the case that says Ashburn, you can read it and read Street, and I'm sure you will have fun looking at both of them. It's because Ashburn is basically always rebutting what Street is saying. It's saying that in the Law of Property Act of 1925, the statute that is used, there was nothing to state to talk about how much to indicate that there must be rent for exclusive possession and a lease. So, or what rent must be or how it must be. So he was saying that basically if there is no rent, you cannot say that there's no lease. But one of the hallmarks of identifying a lease, however, still remains the fact that you must see that the person is paying rent in either cash or kind. So I'm going to wrap up here because I think I have been ranting a long time and you guys are probably tired and stressed out and somewhat confused. So as I said, I will make the list and the table for you guys, but basically I will just review again or just read over. For there to be a lease, exclusive possession, certain period or duration, and rent. If it's just master and servant saying you can lodge while you work on the premises, it's a license. If it's just uncle and niece saying you can stay at my guest house for a week, it is a license. However, there are cases where family relationships may be a lease, because the uncle would have said, well, you are paying me monthly to occupy my premises. And when you're finished paying me all of this money, you can have the property. After 6 months, you can have the property. That's a lease, not a license, because it's not just a gift, oh, you can use my guest house for fun. The next thing is there can be exclusive possession, but it's a tenancy. Sorry, there can be exclusive possession, but it's not a lease. It's a license that's a lease. Why? It's because you're there and you can exclude everyone because you're paying, like we see in Arlington, you're paying the mortgage prices and you're paying money for it, but you're still on a license because it's not rent that you're paying. You're not paying rent, you're paying a mortgage, but because you're paying for it and you can have the property at the end of it, you can exclude everybody else. So you must examine that too. Secondly, there are sham agreements. So I want you guys to read your facts carefully and ensure that where there is a sham agreement, you explain that it's a lease. It's a lease and not a license, because sham agreements mean they just put the word license in there for you to say, oh, it's a license, but it's not necessarily a license. If you see a case, the facts is like that, where you see, oh, all right, so here's agreement, it's a license and you're bound by this license, but at the end of it, you realize that it is for a certain period of rent and there's exclusive possession, then it's a lease. So that's all I will leave you with for there. Oh, and as I said, certain duration does not determine on the time period. It determines on whether the landlord says, oh, I'm renting you this premises for a term determined by me, and I will tell you at a later date or something like that. It's still certain to a duration. And rent, I want you to note that rent, it can be either cash or time. So I will go.
I didn't hear the last part. Is it cash or what?
It can be cash or time. So rent does not necessarily have to be money.
Is it cash or what?
Cash or time.
Every time you say the last part, you break. Yeah. So
Kind. As in, it doesn't have to be money. It can
be.
be.
K-I-N. That's what you say. K-I-N-D.
Yes.
Okay.
Yes.
All right. Thank you.
All right. So I am going to go to the question that I have for you guys. Give me a second. So it's a problem question. Because I know we were going through essays a lot, and we went through a long essay, and you guys are probably tired, and I'm tired too, and hungry. So just give me a second. Oh, I have to share my screen. Wow. Okay. So, question. Punchinello allows his nephew, Pinocchio, to stay in an apartment downstairs his house until he can find an apartment to rent. Pinocchio and his wife move and continue to live there for 16 years, making improvements to the apartment without any objections from Punchinello. Punchinello dies and his wife Tanya informs Pinocchio that she needs the apartment. Pinocchio refuses to move out, saying that his uncle had given him the apartment. Tanya wants to sue Pinocchio to get the apartment back from him. I'm sure now you understand why I spent such a long time on Arlington, because you can read this and see that the case is, this fact is literally the same thing as Arlington, and Arlington, they just probably change out husband and wife and everything and put in uncle and nephew. Just give me 1 minute. All right, so basically, I had missed something from the question where it says to explain to Tanya whether she can succeed in an action to recover the apartment from Pinocchio. All right, so you guys are probably going to have to write again. But I will
Hold on. I thought you said that it was a problem statement. Just explain.
Yes, I just realized it was saying explain.
Yeah, all right. You were saying something earlier about majority of the real property questions. They're what? Essays, you say?
That's what I'm seeing exactly. Because I was going through searching for a property, but everything I'm seeing for a problem, but everything I'm seeing here is a so
Yes,
I was
condition
wondering if I should change to convert the question into something looking like a problem for you guys for time's sake. But let me see something. All right, so I'm going to answer it in something looking like a problem, because it can be a problem question. It's just that it says explain. So it can be a problem question, but just for the sake of time, I'm just going to give you guys an issue, rule, and application, and we just conclude. All right. But the person that was working with me did provide me with an essay, so I will also send the essay for you guys. But for the sake of time, it's almost 5 o'clock. I've been here from 10. So I'm just going to put it into a problem and we just end there. Is that okay? Is that okay?
Yes.
Okay, all right. So the main issue that would be here is whether Pinocchio was let into possession as a leasee or a licensee, and then whether he could claim whether he could be kicked out by his aunt or auntie-in-law. So the rule, it was established in Street v. Mountford. So you have that, right? That the rule was established in Street v. Mountford. Or well, the issue, I don't know if you guys wrote the issue. So whether Pinocchio was let into possession as a leasee or a licensee. As the rule was established in Street v. Mountford, and it states for a lease to be valid, there must be exclusive possession and certainty of duration of the lease. It may be inferred from the facts that Pinocchio was indeed given exclusive possession of the apartment that is downstairs Punchinella's house. Need me to repeat, or everyone is fine, or you will listen afterwards?
So you said that you were going to send that to me, so.
Okay, all right, no problem. All right, so I can just read and go along then. All right, so there is, that's why I was going on. I'll just read and go along. There is no mention of any conditions that would rob the occupation of its status as exclusive. However, no date is given for the termination of Pinocchio's occupancy. The period of occupancy, is therefore uncertain, as Pinocchio was only granted occupation until he could find another apartment. This is not sufficiently determinable, as it is unknown as to exactly when he will find another apartment. This was held to be the position in Lace v. Chantler, in which the tenant was let into possession until the end of the war. The lease was held to be void for uncertainty. even proceeding on a wider interpretation of the facts, having regard to the intention of the parties. It is unclear whether the lease has been created. It is, however, possible that Pinocchio may be a tenant at will. De la Bastide, J.A. in Romani and Romani, opinioned that a tenancy at will exists when one enters into possession of the premises of another, and understanding that he may go at any time and that the landlord may terminate the tenancy at any time. He further stated that it is a personal relationship between the landlord and the tenant. It is important to note that a tenancy at will may be created by implication. An instance of implication may arise where one takes possession under a void lease. On the facts, it can be said that Pinocchio has taken possession under a void lease, as we are not certain of the duration of the lease. Notwithstanding that Pinocchio may be a tenant at will, Tanya is advised that she may indeed recover possession of the apartment from Pinocchio, as it is very likely that she has now become the legal owner of the house as a result of her husband's Punchinella's death. If Pinocchio is indeed a tenant at will, Tanya, the new landlord, may terminate the tenancy at any time. Conclusion, Tanya may legally recover possession of the apartment from Pinocchio. And this is because it is different from Arlington and Arlington. So you can also make that examination when you're answering, or in your application. Is different from Arlington, because in this case, Pinocchio was a tenant at will. And it's not like in Arlington and Arlington, where they weren't actually paying rent, they were actually paying a mortgage. And so they would have gotten the premises at the end of paying the mortgage. So where she paid the mortgage and the tenants and she finished paying the mortgage, she gets the property because she paid all the mortgage. She paid for the property, so nobody could take her out of it. But it is different when someone is a tenancy at will, because when you're a tenancy at will, it means that your landlord can terminate your contract at any time. Given that Tanya's husband, Punchinella, died, more than likely the property went to her. And this is why land ownership and co-ownership is somewhat so close. So given that she was his wife, more than likely he probably willed the entire property to her. And if she gets the property, then she's now the landlord and she can terminate his lease, because it's a lease, it's a tenancy at will, and it's not a case like in Arlington and Arlington where you could pay the mortgage until where you were paying mortgage. So basically, after you don't pay mortgage, that property is yours. Nobody can get you out of it. Versus where it's tenancy at will, where your landlord can terminate your lease at any time. So that's for that. I will also, as I said, I will get the essay to you guys later on or tomorrow. When is your exam? When is your exam? Anyone? Is it Monday? Anyone is going to answer me?
No, I think it's the 7th, if I'm correct.
Okay, all right. So I'll get the
week after next.
Week after next. All right, so I'll get the information to you by Monday. Monday evening. Yeah, Monday.
Thank you for your time also. It's the 8th of June, I think it's saying.
The 8th of June. Okay,
Yes.
all right. Are there any other questions?
Another? No questions.
Okay, all right. So I think that's the end of it for us. We will send you, and now that I know that you're only getting things on land ownership and co-ownership, I will try to find if I can put any other information, and I will get it to you guys as well in the group.
Yes, another thing too. Probably you could, I don't know the other person that did module 2 would probably, do the same and probably gather a little 1 and 2 notes for us on contract and probably vicarious and strict liability for module 1. Because I don't remember you doing that. So I don't know if you could reach out to that person on our behalf and see what they can match for us.
Okay, all right, we'll do that. So according to your syllabus, you're getting vicarious and strict liability for torts, right?
Yes, we are.
Okay, all right. So we will, all right. So I will speak to Samoya and we will work on that.
Thank you very much. Thank you for your time.
You're welcome. No problem. Have a good evening, everyone.
Thanks, same to you.